There, how's that?
Sounds good. I can hear you.
Hate it when I don't get these things working.
Good morning, Your Honor. My name is Addie and I am your bailiff for this trial. Please let me know as soon as you would like for me to call the court to order.
Okay, we'll give you just a minute. And Adija, there's at least 2 times where you have to call the court to order. And I previously kind of screwed that up. So you'll be calling everything to order after I first ask the people to introduce themselves. And then I'll give the instructions. And then you call them to order another time when I begin the pretrial motion. Okay. Let me close the door and then I'll be ready. We're starting early. Good. I am ready when you all are.
Your Honor, the defense is ready to proceed.
Good morning.
Good morning.
Your Honor, the prosecution is ready to proceed as well.
Good morning, Your Honor. My name is Albert Jen, prosecution pretrial attorney.
I haven't asked anyone to introduce themselves yet.
My apologies, Your Honor.
Okay, bailiff, is everyone ready?
I believe so, Your Honor.
Are there any substitutions?
Not that I'm aware of, Your Honor.
Okay, good morning, everyone. This is Judge Mooring. To help myself and the attorney scores, will the prosecution team state your name and role, please?
Good morning, Your Honor. My name is Albert Jen, prosecution pretrial attorney.
Good morning, Your Honor. My name is Jasmine Criqui for the people.
Good morning, Your Honor. My name is Benjamin Feng for the people.
Good morning, Your Honor. My name is Dylan Thomas for the people. At this time, may our witnesses please introduce themselves?
Yes.
Good morning, Your Honor. My name is Grace Kish, and I am Remy Montoya.
Good morning, Your Honor. My name is Diane Zhou, and I am Officer Max Bird.
Good morning, Your Honor. My name is Addison Flanagan, and I am Drew Marshak.
Good morning, Your Honor. My name is Ava Amen, and I am Dr. Kai Chavez. At this time, may our court clerk please introduce himself?
Yes.
Good morning, Your Honor. My name is Joshua Yu, and I'll be serving as the court clerk for today's trial. Now at this time, may I introduce the timing rules for the court?
Yes.
I'll be giving both visual and verbal time cues of 2 minutes, 1 minute, 30 seconds, as well as a visual and verbal stop. Now at this time, may our alternates please introduce themselves?
Yes.
Good morning, Your Honor. Cole Frost, pretrial attorney alternate.
Good morning, Your Honor. Marissa Gaut, attorney alternate.
Good morning, Your Honor. Darren Chan, attorney alternate.
Good morning, Your Honor. Zhou Canipe, witness alternate for Remy Montoya.
Good morning, Your Honor. Victor Bonhomme, witness alternate for Officer Max Bird.
Good morning, Your Honor. Olivia Schroeder, witness alternate for Drew Marshak.
Good morning, Your Honor. Kaolyn Roberts, witness alternate for Dr. Kai Chavez.
Good morning, Your Honor. Nikolas Renner, clerk alternate. Now with that, may our attorney coaches and teachers please introduce themselves?
Yes.
Good morning, Your Honor. My name is Jack Milner, teacher advisor for the prosecution.
Good morning, Your Honor. Robert Trestman, attorney coach for the prosecution.
And good morning, Your Honor. Brandon Saxon, attorney coach for the prosecution.
The defense team, please state your name and role.
Good morning, Your Honor. My name is Anjali Bose, and I will be presenting the pretrial motion on behalf of my client, Lee Croddy. At this time, my co-counsel will introduce themselves.
Good morning, Your Honor. My name is Kennedy Younghome, and I, along with my co-counsel, represent Lee Croddy.
Good morning, Your Honor. My name is Mariah Hamilton, and I, along with my co-counsel, represent Lee Croddy.
Good morning, Your Honor. My name is Burr Al-Jaybaji, and I, along with my co-counsel, represent Lee Croddy. At this time, our witnesses will introduce themselves.
Good morning, Your Honor. My name is Megan Greer, and I am Dr. Jes Beeart.
Good morning, Your Honor. My name is Caitlin Kempf, and I am Zuri O'Neill.
Good morning, Your Honor. My name is Morgan Montesi, and I am Erin Sullivan.
Good morning, Your Honor. My name is Katie Jacques, and I am Lee Croddy. At this time, our bailiff will introduce herself.
Good morning, Your Honor. My name is Addie Nayak, and I am your bailiff. At this time, our unofficial time clerk will introduce themselves.
Good morning, Your Honor. My name is Ashuta Date, and I will be the unofficial time clerk for this round. At this time, our attorney coaches will introduce themselves.
Good morning, Your Honor. Lori Weston, attorney coach for Team DD.
Good morning, Your Honor. Peter King, attorney coach for Team DD.
Good morning, Judge Mooring. Scott Taylor, attorney coach for Team DD.
Good morning, Your Honor. My name is Nick Spees. I'm the teacher advisor for Team DD. Oh, sorry, Team D.
With that, the defense is productions are done. Thank you.
Bailiff, please call the trial to order.
All rise. Superior Court of the State of California, County of San Diego, Department 2 is now in session. This is the case of People v. Lee Croddy. The Honorable Judge Dwayne Mooring presiding. Please be seated and come to order. For the proceedings of this trial, if you are not presenting, please keep your microphones muted and your cameras off. If there are any substitutions, team members must notify me. If you are being disruptive, I will have to ask for you to leave the room. Thank you.
Thank you, Bailiff. Good morning, everyone. I know we are at the semifinal round, so you've all been given the instructions plenty of times before, but I am going to review the instructions one more time pursuant to the script. You must complete your presentations within the specified time limits. The clerk will signal you as your time for each section of the presentation begins to run out. When your total time for each section runs out, you will be stopped, even if you have not finished. Attorneys must call all 4 witnesses within the time limit. This is a bench trial. At the end of the trial, I will render a verdict of guilty or not guilty in relation to the charge brought. The teams will be rated based on the quality of their presentation. Independent of my verdict is irrelevant to the scoring. No recess will be called. If for any reason a brief delay occurs due to technical issues, team members must remain in their appropriate places and should have no contact with spectators or coaches. Remember that objections are limited to the California Mock Trial Simplified Rules of Evidence located in the case packet. If there are no questions, pre-trial arguments will begin. And Bailiff, please call the hearing to order.
This is the case of People v. Lee Croddy.
Both sides have 4 minutes to present their arguments. Defense will begin. I will interrupt to ask clarifying questions. Time spent answering my questions is not included in the 4-minute time limit. At the conclusion of your arguments, each side will be offered 2 minutes of rebuttal time. Remember that the rebuttal time is to be used to counter your opponent's arguments. It cannot be used to raise new issues. Is counsel for the defense ready to begin?
Yes, Your Honor.
Please summarize your arguments.
Thank you, Your Honor. May it please the court. The defense moves to exclude the conversation on February 16, 2020, between Officer Byrd and my client, Lee Croddy, as it was the fruit of an unmirandized custodial interrogation. Your Honor, under the Fifth Amendment, there are two parts to custodial interrogation: custody and interrogation. The case of Stansbury v. California defines custody as the objective circumstance of the interrogation and whether or not a reasonable person would feel free to leave. For custody, the Lewis case is instructive. The Lewis court found a custodial setting when the defendant was in the back seat of a stationary police vehicle. Even more convincingly, in our case, my client was not only in the back seat of a police vehicle, the car was moving in our case. Your Honor, being in the back seat of a moving vehicle that's being driven by an authoritative figure of the law, no reasonable person would feel as though they are free to leave.
Counsel, let me interrupt you. You did mention People versus Lewis.
Yes, Your Honor.
Now, in the case before this court, the defendant was not even detained, unlike the defendant in the People versus Lewis. So how do you distinguish the holding of Lewis from this case?
Yes, Your Honor. While my client was in the back seat of the car, she was being treated as though she was effectively under arrest, as was the defendant in the case of People v. Lewis. My client was in the back seat of a moving vehicle, unable to leave. And under Stansbury v. California, the definition for custody is whether or not a reasonable person would have felt free to leave, Your Honor. Furthermore, my client had asked for counsel, which no reasonable person would have requested had they believed that they were free to leave. Turning now to interrogation. The case of Rhode Island v. Innes held that interrogation is present if any words or actions on the part of Officer Byrd were reasonably likely to elicit an incriminating response. For interrogation, the case of People v. Boyer is instructive to our case today. The Boyer court found interrogation when the defendant's request for counsel was ignored, and instead, a conversation about the case was created by the officers. Like Boyer, Officer Byrd had ignored my client's right for counsel. And like Boyer—
Counsel, now didn't People versus Anderson hold that casual conversations are permitted? And
yes,
they do not require the prerequisite of the defendant being read his Miranda rights, even if the resulting conversation produces incriminating evidence. So weren't the comments by Officer Byrd simply casual conversation?
No, Your Honor. There was no casual conversation in this car ride. The case of People v. Andreasen held for a casual conversation to be permitted that the conversation revolved around neutral topics and was used to diffuse a situation in which the defendant was angry and delusional. In our case today, first, the conversation was not of a neutral nature, as Officer Byrd had accused my client of anarchy, and had provoked my client to a point where she was reasonably likely to elicit an incriminating response, using demanding phrases such as, "You have to admit." Furthermore, my client was not angry or delusional, like in the case of People v. Andreasen. She was compliant with the officer and was not showing no signs of being anything like the defendant in People v. Andreasen. As such, the holding of Andreasen that found casual conversation to be permitted does not apply here today. Instead, turning back to the California Supreme Court case, People v. Boyer, where interrogation was found because the defendant's right to counsel was ignored and the officers created a conversation about the case, that is far more applicable to our case today.
Counsel, Officer Byrd testified that Croddy was not detained, and Officer Byrd did not even consider Croddy to be a suspect when Officer Byrd initiated the conversation in the police car. So what significance does Officer Byrd's subjective belief that Croddy was not a suspect mean to you in regards to whether the defendant was in custody pursuant to the case of Stansbury versus California?
Yes, Your Honor. Given the latest mock trial errata, the portion about Ms. Croddy not being a suspect nor a witness was removed. However, for Stansbury v. California, my client believed that she could have been a suspect in the case. And under Stansbury v. California, it is the custody is defined from the reasonable standard of a person in the suspect's position and whether or not they are free to leave. In this case, Your Honor, my client would not have believed that she was free to leave. Looking at the totality of the circumstance, we can see that Ms. Croddy had known that Officer Byrd was requiring information from her, and this information was pertinent to the case that she was investigating. No reasonable person in my client's position would have felt free to leave under these circumstances. Your Honor, the nature of the conversation itself is telling. Here, Officer Byrd had initiated the conversation and had done so by accusing my client of being an anarchist after having just arrested a suspect at my client's house who was criticizing the government, saying that the government lies. Anarchy. That's exactly what Officer Byrd had accused my client of. Your Honor, the fact of the matter is
2 minutes.
My client was not free to leave while in the back seat of a moving police vehicle. Officer Byrd had just arrested a suspect at my client's home who was criticizing the government and suggesting that my client may have been involved with the underlying crime. Officer Byrd had ignored my client's request for counsel. Your Honor, under Stansbury v. California and Rhode Island v. Innis, the un-Mirandized statements procured from Ms. Croddy constitute both as in custody and as an interrogation, and as such is a violation of my client's Fifth Amendment rights.
1 minute.
If the court has no further questions, the defense respectfully requests that our motion to exclude be granted. Thank you, Your Honor.
Thank you, counsel. Is counsel for the prosecution ready to begin?
Yes, Your Honor.
Please.
Your Honor,
your arguments.
Your Honor, it's the prosecution's position that Lee Croddy's statements on page 32, 39, and 40 be allowed in today's trial. Firstly, because it would be a flagrant mistake to label the interaction as a custodial interrogation. And secondly, because of the fact that there was zero elicitation of incrimination. Now, the central issue in this case, as explained on lines 36 through 44 of page 16, is whether a custodial interrogation took place in the unmarked police vehicle. Lines 6 through 13 of page 16 breaks it down for us. There are just two components to custodial interrogation. First, the circumstances of the interrogation must objectively amount to custody, meaning that it cannot be a casual conversation. And second, there must be an interrogation where the officer should positively know that their questions could produce incriminating responses.
And counsel, that raises an interesting issue. Doesn't Rhode Island versus Innis hold that the words or actions of a police officer may be in the form of explicit questioning or the functional equivalent of such questioning if the officer should have known that their brief conversation in the defendant's presence was reasonably likely to elicit an incriminating response? Thus, why weren't the questions accusing the defendant of being an anarchist an interrogation?
Absolutely, Your Honor. To answer your question, in Rhode Island v. Innis, the court's analysis admitted that without that reasonable elicitation that you discuss of incriminating evidence, the event cannot be considered an interrogation. But the fact of the matter is that insofar as having one's content being taken out of context from an anarchist perspective. There is no charge and no crime that is connected, or there's no charge or crime for being an anarchist or having your videos being taken out of context. Nothing in the conversation is there any further incriminating accusation. Given that all of the questions were not surrounding incrimination, that's when Rhode Island v. Innis's ruling falls short.
Please,
Your Honor, may I continue?
Yes.
We'll begin by disproving the first qualification. This is why the circumstances did not ignite feelings of custody. Lee Croddy made the decision herself to accept a carpool offer, an offer of transportation. Lee Croddy opened the unmarked police car's door, sat herself down, and accepted the offer for a ride to the police station, all of which was under her very own volition. And even though the defense will champion this single police radio sitting in the front seat as an end-all, environmenting disrupting piece of evidence, even though Officer Byrd's occupation was made clear to Lee Croddy, I direct the court's attention to two distinguishing factors. First, the vehicle sported a civilian plain paint job and its roof was devoid of a police siren. And second, the interior of the vehicle was devoid of the traditional metal cage that is supposed to separate the front seat from the back seat. So
now,
while opposed,
counsel, people v. Boyer held that a coercive environment that diminishes the defendant's ability to exercise his Miranda rights deems the resulting statements inadmissible. You're raising some interesting points regarding the vehicle, but why do you believe that the line of questioning by Officer Byrd does not create a coercive environment?
Firstly, I'd like to discuss the very first part of your question, which is answered by page 16, lines 13 through 14, which dictate that this test of whether or not custodial interrogation exists is a two-part test that is objective and based on a reasonable person's perspective. It is the prosecution's position that putting a reasonable person in a police car with a siren, a black and white paint job, a metal isolating cage, driven by an officer in uniform is much more custodial than Lee Croddy sitting in the back seat of a civilian car being driven by a person in her daily clothes and having the full freedom to just reach across to the front seat. And the defense also equates the moving car to custodial interrogation in line with the questions that were surrounding it that you mentioned in your questions. But understanding that the backstory of the carpool was an offer of transportation suggests that a simple question of, may we stop the car for me to exit, would suffice.
Now, I've got one more question for you, counsel. And if I'm not following the specific rules, please bring it to my attention. This is regarding Stansbury versus California. It's the same question I posed to opposing counsel. Now, Officer Byrd testified that one, Croddy was not detained, and Officer Byrd did not even consider Croddy to be a subject when Officer Byrd initiated the conversation in the police car. But again, what significance does Officer Byrd's subjective belief that Croddy was not a suspect mean to you in regards to whether the defendant was in custody pursuant to Stansbury versus California?
Absolutely, Your Honor. The reason why the prosecution's position is that Stansbury v. California does not apply to the case, contrary to what opposing counsel believes, is that Stansbury, the defendant, was questioned in a physical police station, a police station that requires a physical entry, during which a reasonable person, in line with the two-part test, a reasonable person would see numerous other police at work, a sign, actual police cars that do not blend in with the rest of society's vehicles, and overall an environment that very clearly shouts, you are in police territory and custody as a suspect. Now, comparatively, in today's case, the two settings with Stansbury versus Croddy, in Stansbury, the situation is a lot more custodial than the one that we are discussing today.
Go on.
Now, while opposing counsel paints a picture of an isolated Lee Croddy, the prosecution would like the court to remember that it was Lee Croddy's very own decision to accept a carpool offer from a civilian painted car with no police siren and a no metal cage separating the back seat from the front seat. This casual nature and casual setting of the unmarked police car matters in today's holding, because in the case of People v. Torres, the court's analysis admits that universally, no interrogation means no to a requirement of Miranda warnings and yes to admissibility. Now, moving on, the second mandatory condition of custodial interrogation falls flat as well. The defense's burden further requires that the conversation was designed deliberately by Byrd to elicit incriminating evidence from Lee. And in Rhode Island v. Innis, the court's analysis admitted that without that reasonable elicitation of incriminating evidence, the event cannot be considered an interrogation. Here is that very exact situation in today's case. Officer Byrd's grand scheme of just connecting a familiar face to a social media influencer was simply asking Lee about their content being taken from an anarchist perspective. Nothing in the conversation is there any further incriminating accusation, because insofar as having one's content being taken out of context from an anarchist perspective, that's simply not a crime, Your Honor. And furthermore, facts of pretrial on page 17 solidify the absence of eliciting incrimination. Officer Byrd specifically stated that she was not talking about Ms. Montoya's actions and that she was speaking generally about Ms. Croddy's content being misinterpreted. In fact, the direct quote from Officer Byrd is as follows: "I was speaking generally that your content can be taken out of context." So with the recognition of a casual conversation and the absence of eliciting incrimination, the prosecution respectfully requests that you admit the statements made by Lee Croddy in today's trial.
Thank you. Does the defense have a rebuttal?
Yes, Your Honor.
You may proceed.
Thank you, Your Honor. First, to address opposing counsel's use of Stansbury. Given the mock trial case packet, there is no holding. So opposing counsel's use saying that there was no custody found in Stansbury falls short. First, to address opposing counsel's points about custody, my client did not enter the vehicle voluntarily. She was asked to go into the vehicle. And furthermore, she did not sit herself in the back seat. There is nowhere in the case packet that states whether Officer Byrd put her in the back seat or whether she got in herself. Next, the unmarked vehicle that opposing counsel claims is so relevant to the holding for custody in this case falls short once again, as no reasonable person would doubt that Officer Byrd was in fact acting in official police capacity. Officer Byrd had shown their badge, had said that they were investigating a crime that was committed at that the suspect was found at my client's home. No reasonable person would doubt that. This was a coercive environment, similar to that of People v. Boyer, in which my client could not leave the vehicle. Officer Byrd had ignored my client's request for counsel, just like in People v. Boyer. Officer Byrd had initiated a conversation about the case by accusing my client of being an anarchist, saying, "You have to admit." And furthermore, Officer Byrd is saying, "You're taking what I'm saying out of context." That was not diffusing the situation like in People v. Andreessen. Officer Byrd continued to pointedly egg on my client. Your Honor, denying the defense's motion sends a dangerous precedent of eroding my client's constitutional freedoms. If the court has no further questions, the defense respectfully requests that our motion to exclude be granted. Thank you, Your Honor.
Thank you. Does the prosecution have a rebuttal?
Yes, Your Honor. To clear up the misunderstanding, on page 17, lines 18 through 19, the case packet declares that Lee Croddy was sitting in the backseat after Lee Croddy accepted the carpool offer. Now, moving on, the prosecution is confused as to the opposing counsel's attempt to champion People v. Lewis. This landmark case is a safety net for the prosecution, because even if the situation did amount to custody, People v. Lewis dictates that not requiring Miranda warnings still applies to casual conversations, even if the defendant was in a custodial setting. If the court's analysis admits this, there is no question to the admissibility of today's case, given that that setting was far from custodial in an unmarked police car during an offer to carpool. And the case People v. Boyer, which the opposing counsel pedestals their argument on, does not apply to the case at hand for this reason. In People v. Boyer, the detectives failed to honor the defendant's consistent and explicit request for an attorney.
1 minute.
Comparatively, in today's case, all Lee did was ask if he needed an attorney, which does not amount to an assertion of his Miranda rights. And lastly, the defense also equates a moving car to a custodial interrogation. Understanding that the backstory of the carpool was an offer of transportation suggests that any simple question, just like the one, "May we stop the car for me to exit?" would suffice. And with that being said, Your Honor, with the recognition of a casual conversation and the absence of eliciting incrimination, the prosecution respectfully requests that you admit the statements made by Lee Croddy during their casual conversation with Officer Byrd in today's trial.
Thank you, counsel. Before I rule on the motion, students may confer with their attorney, teacher, coach regarding any trial irregularities. Please do so now. You have 60 seconds.
Thirty seconds. Stop.
Would the prosecution team like to note any trial irregularities?
No irregularities, Your Honor.
What about the defense team?
Yes, Your Honor. 2 trial irregularities. May I proceed?
Yes.
Under Rule 3.7e, no additional background research may supplement the argument, the prosecution's understanding of the issues at hand, and such supplemental materials may not be cited in the argument. The first instance in which this rule was violated was when opposing counsel had brought up the holding of custody in the case of Stansbury v. California. Second, the prosecution had mentioned the burden of proof and had given it to the defense. However, in the case packet, there is no mention of which side is awarded the burden of proof, and that is incorrect.
Thank you, counsel.
Thank you, Your Honor.
I will now rule on the motion. I find that the defendant was in custody, and further, that the officer's questions did amount to an interrogation. Therefore, the motion by the defense pursuant to Miranda is granted. We will now begin the trial portion. The parties may now present their evidence.
Your Honor, before we begin opening statements, the prosecution would like to handle a few preliminary matters.
Yes.
We would like to pre-mark Exhibit A, B, and C. Exhibit A being found on page 48 is an image of Drew Marshak's briefcase. Exhibit B being found on page 49, it is a screenshot of the February 12th Twitter group chat. And Exhibit C, being found on page 50, is a screenshot of the February 14th WhatsApp text conversation between Lee Croddy and Remy Montoya.
Is there any objection?
No objections to Exhibits A, B, and C being pre-marked for identification purposes only.
All right. And is the defense going to present any evidence or exhibits?
No, Your Honor.
I will now read the charges against the defendant. The people of the state of California are charging the defendant, Lee Croddy, in 2 counts. 1, aiding and abetting a first-degree burglary committed by Remy Montoya, and 2, as an accessory after the fact to a felony committed by Remy Montoya. Prosecution, are you ready to present your opening statement?
Yes, Your Honor.
You may proceed.
Your Honor, my name is Jasmine Criqui, one of the prosecutors representing the state of California in this action. 1 innocent victim, 1 young, vulnerable fan. As you hear this case today, know that the fateful meeting between these two was not orchestrated by destiny, but by a puppet master, an expert manipulator who used their celebrity status to advance their own agenda. On February 15th, Drew Marshak's home was broken into, her property was taken from her, and her sense of privacy and security was shattered. No one in this courtroom today disputes the injustice of this incident. However, it would be a gross oversimplification of the case before us to only consider the events of February 15th in order to assign guilt, when in reality, February 15th's injustice was the culmination of a months-long effort by the defendant to emotionally manipulate Remy Montoya, one of the defendant's most devoted fans, into committing the crime that the defendant didn't want on her own hands. Calcrim 400 and 401 explain that the defendant has aided and abetted a crime if the defendant knew the perpetrator meant to commit the crime and consciously helped them to do so. Furthermore, Calcrim 440 identifies the defendant as an accessory to a crime if the defendant knew that the crime had been committed and still acted in order for the perpetrator to avoid arrest. Today, Ms. Montoya herself will shed light on how the defendant took advantage of her adoration of her by singling her out specifically, despite the presence of multiple other fans of the defendants in Beacon Hills at the time of the meet and greet, and by puppeteering her into believing that the defendant's career was dependent on the documents, and by extension, Ms. Montoya. Furthermore, Drew Marshak will testify to the harm she suffered as a result of the defendant's machinations, to the distinctive nature of her briefcase, and to Ms. Montoya's addled state at the time of the incident. Then, Officer Max Bird will lay out the defendant's franticness upon Ms. Montoya's arrest and her knowledge of Ms. Montoya's wrongdoing. Finally, the prosecution will prove that not only did Lee Croddy have full knowledge as to the lengths that Ms. Montoya was willing to go to appease her, including crossing the line into violence, but that she methodically and purposefully perpetuated Ms. Montoya's adoration in an online setting through the use of groupthink, a manipulative practice that Dr. Kai Chavez will walk us through. Not only did the puppet master give Ms. Montoya all of the information and motivation she needed to commit this heinous crime, but she harbored her after the fact until a neighbor alerted the police of Ms. Montoya's presence in the defendant's home. By the conclusion of this trial, myself and my co-counsel, Dylan Thomas and Benjamin Feng, will have proved beyond all reasonable doubt that the defendant, Lee Croddy, is guilty of both aiding and abetting a first-degree burglary and accessory after the fact. Thank you.
Thank you. Defense, are you ready to present your opening statement? Or do you
Yes,
wish?
Your Honor.
I'm sorry, we spoke over each other. Defense, are you ready to present your opening statement or would you like to reserve?
The defense is ready to proceed to opening statements now, Your Honor.
You may proceed.
Your Honor, this is a case of one burglar, one mind, and one criminal. That one criminal being the prosecution's star witness, Remy Montoya. Montoya was the only one who committed these crimes, and now after being caught, is attempting to evade responsibility and wrongfully deflect the blame onto my client, Lee Croddy. Montoya is the only one facing up to 5 years in prison, but their sentencing will not be until after their performance at today's trial. Now, during the course of today's trial, the evidence will show that Lee Croddy did not want any crime to be committed, that Lee Croddy was not aware any crime had been committed until Remy's arrest. One burglar, one mind, one criminal. You will hear Remy admit to having grandiose plans about being hailed as a hero for stealing confidential documents. Prosecution witness Drew Marshak will testify that Remy is the only one who broke into Agent Marshak's home, stole confidential government information, violently attacked Agent Marshak, and fled the scene. One burglar. Now, the prosecution's opening just made bold statements about how my client's words and group and private chats will somehow prove my client's intent to manipulate Remy Montoya into committing these crimes. We ask that you consider the whole story and carefully compare that the criminal activities of what Remy Montoya actually committed and the words my client actually said. The evidence will show that they do not match up. In fact, Montoya will admit that their criminal activities went beyond of what my client actually said. Now, Remy Montoya was the only one who imagined orders to burglarize and assault Agent Marshak. To context, Lee and Remy were a part of a group chat with 5 other group chat members. Zuri O'Neill, one of those other 5 group chat members, will testify to understanding Lee's passionate messages as just normal, harmless venting. Expert witness Dr. Jes Beeart will corroborate how Remy's actions were done independently of Lee Croddy. One mind. And finally, even though she has a constitutional right to remain silent, you will hear from Lee Croddy herself. You will hear how she is a host of a popular YouTube show called The Right Choice of News, how the show offers a space for over 1 million fans to gather and discuss current events, and how Lee wanted fans to act responsibly, not criminally, to uncover the truth around government conspiracies. Erin Sullivan, Lee's agent, will testify that Lee is a kind, caring person who appreciates the support of all her fans like Remy, and because of that kindness, first invited a frantic Remy to wait patiently in a public meet and greet, and eventually invite Montoya home to calm down. The evidence will show that Lee did so without knowledge of what Remy Montoya had done. We ask you to listen very carefully to Remy Montoya's testimony today, because they will admit to never sharing the stolen information with Lee at any time, and also admit to never telling Lee about the crimes they had just committed alone. One criminal. And unlike Remy, you will hear how Lee Croddy was compliant with the police during their investigation. One burglar, one mind, and only one criminal here. The prosecution will not be able to meet their high burden of proving beyond a reasonable doubt that my client aided and abetted a burglary and was an accessory after the fact. Thus, at the conclusion of this trial, my co-counsel, Ms. Aljay Abaji, will respectfully request that this court find my client Lee Croddy not guilty on both charges. Thank you, Your Honor.
Thank you. Prosecution, you may call your first witness.
The prosecution calls Remy Montoya to the stand.
Remy Montoya, are you present?
I am.
Remy Montoya, please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Can you please state your full name and spell your last name for the record?
Remy Montoya, Montoya.
And for your honor's convenience, the statement for this witness can be found starting on page 25 of the case packet. Thank you.
Thank you.
Your Honor, before I begin the direct examination, the people request that the defendant turn on their camera for a brief moment so that the witness can note identifying features.
Motion's granted.
Ms. Montoya, do you know Ms. Croddy?
I do.
Do you see them on the screen?
Yes, they have green hair and a black shirt.
Objection, Your Honor. This is not relevant, as it's been stipulated that the defendant is recognized in the courtroom.
The objection is sustained.
May the record reflect that the witness has identified the defendant.
No, that objection was sustained. You had a stipulation to that fact.
Oh, my bad, Your Honor. Ms. Montoya, could you please introduce yourself to the court?
My name is Remy Montoya. I'm 21 years old, a sales associate for Thinker Toys Corporation, and a proud student at Beacon Hills Community College. Just looking to minimize some student debt. You know how it is.
Thank you. And how did you first become acquainted with the defendant?
I first found one of Lee's videos while researching the Roswell UFO crash of 1947. It was out of this world. I mean, I immediately fell in love with all of Lee's content and followed all of her socials.
Was your only connection to Lee through watching her videos?
That's how it started, but in March, Lee invited me to join a group chat with her and around 5 other passionate fans. In July, I was chosen to go to a panel and to have lunch with Lee, and in August, I was even lucky enough to appear on one of her Instagram live streams.
What other direct interactions, if any, did you have with her?
I've met her at a couple of her meet and greets, but we've also communicated 2 to 3 times per week through comments, likes, and the group chat.
Moving on, could you briefly walk us through the events on February 12th, 2020?
Of course. The day before, Lee had tweeted about an exciting upcoming video regarding government secrets. On February 12th, Lee sent a sneak peek of the video to the group chat, along with some messages saying things such as taking what is ours.
Objection, Your Honor. This witness is lulling into a narrative.
Overruled.
Ms. Montoya, did you get a chance to finish your statement?
I did not, but I can continue. Lee sent our group chat messages saying things such as mobilizing, taking what is ours, and demanding answers. Lee also held up some official-looking documents in the sneak peek video.
What, if anything, was shown on the documents included in the sneak peek?
There was the name and address of the government official, Zhou Marshak.
Was there anything particularly important from the full video?
Once it was fully released, I felt that there was this direct call to action from Lee to us group chat members. I remember Lee saying to get down to where that official lives if necessary and to demand answers.
What do you mean by a direct call?
Well, I felt it was a direct call because, to my knowledge, the group chat members were the only ones with access to the sneak peek video and the address.
Was there anything particularly important that happened the day after this direct call?
Lee messaged me asking if I was in the Beacon Hills area. I was, so I messaged her back confirming.
Ms. Montoya, do you have Exhibit C on hand?
I do.
Do you recognize Exhibit C?
Yes.
What is it?
It is a February 14th WhatsApp text conversation between Lee and I.
Is this a fair and accurate representation of your text conversation?
It is.
Your Honor, the people request that Exhibit C be moved into evidence.
Any objection?
Yes, Your Honor. The defense objects to this exhibit on grounds of hearsay. While the defense understands that Lee Croddy's words can come in as admission by party opponent, there are other statements being made by Remy Montoya. And as such, the defense requests that those are limited only to foundational purposes and not for hearsay.
And again, which exhibit is this? Is this B or C?
This is Exhibit C, Your Honor.
C? Okay. Is there any response to the objection? It's a hearsay objection, is that correct, counsel?
Yes, Your Honor.
Any response
Yes,
to
Your
the
Honor.
hearsay objection?
Yes, Your Honor. All of Remy Montoya's statements, as shown in Exhibit C, are simply showing Remy Montoya's state of mind in responding to Lee and are not offered for the truth of the matter. For example, page 50, lines 25 to 27 says, "I'm honored to help in any way I can." It is clear that these statements are only showing Remy's state of mind and are not offered for the truth of the matter.
Okay. I'm going to overrule the objection, and the exhibit will be admitted into evidence.
Ms. Montoya, do you mind reading lines 11 to 13?
I need you to go to that Agent Marshak's place. It's near you. Get the rest of the documents.
Ms. Montoya, do you also mind reading lines 29 to 31?
I know you do, but we need those documents, Remy. You really need to get into that house tomorrow.
Thank you, Ms. Montoya. After Lee sent you that, what happened next?
I did what I was asked to do. I got the documents. On February 15th, I broke into Mrs. Marshak's house, took information off of her computer, took her briefcase, and ran into her on my way out.
Objection, Your Honor, non-responsive.
Your Honor, may be heard.
Yes.
Your Honor, my question was what happened next? Ms. Montoya is clearly describing what happened after she received the text. It is responsive.
The objection's overruled.
Ms. Montoya, did you get a chance to finish?
No, but I'll continue. I ran into Mrs. Marshak on my way out. She tried to take the briefcase back, and in my panic, I punched her in the face and then ran out of the house.
What did you do immediately after?
Well, I was really overwhelmed because it was never my intention to hurt anybody. So I thought the best thing to do—
Your Honor, non-responsive.
Your Honor, may be heard.
Yes.
Your Honor, not only is how Remy was feeling after leaving Ms. Marshak's house really important to explaining her decision-making calculus, it also is something she did immediately after. Feeling emotions is doing something, and therefore this is within the scope of the question.
Your Honor, may I be heard?
Yes.
Your Honor, the question was asked to what Remy Montoya did, not what Remy Montoya was feeling.
Your Honor, may be heard.
Yes, and this is the last time I'm going to hear anything before I rule.
Of course, Your Honor. Once again, feeling emotions is still doing something. Therefore, this still falls under the scope of the question.
Okay. All right, the objection's overruled. I'll allow the testimony.
Ms. Montoya, do you need me to repeat the question?
No, I can continue. Because I was feeling overwhelmed, because it was, again, never my intention to punch anybody, I thought the best thing to do would be to go to the scheduled meet and greet, find Lee, and ask for her help, and I took the briefcase with me.
Once you got there, what did you say to her?
I specifically remember telling Lee that I had gotten the stuff she wanted from the house, but that I had to run in with Mrs. Marshak.
Your Honor, may I be heard?
Yes.
Your Honor, not only is this an exception to hearsay because it is a declaration against Remy Montoya's interest, in this point confessing to a crime which subjected the declarant to the risk of criminal liability, it is also an excited utterance as Ms. Montoya was still under the stress as of the event that had happened.
All right, I'll allow it under both grounds.
Ms. Montoya, did you get a chance to finish? Ms. Montoya?
Excuse me, I'm here, sorry, my internet. I did get a chance to finish.
And how are you able to eventually overcome your state of panic?
I didn't do it alone. Lee offered me a ride back to her place and assured me that no problem was too big to be solved, which was relieving.
What, if anything, happened on the car ride back to her home?
In my frustration, I shouted something about all my problems being because of the stupid briefcase. Lee asked if it was just a prop, and I got angry. Because why would I be freaking out so much over something as little as a prop?
Objection, Your Honor. Non-responsive.
May opposing counsel clarify as to which point is non-responsive?
Your Honor, the point that is non-responsive is why she would be angry as to the briefcase being a prop as suggested by my client.
Your Honor, may I be heard?
Yes.
Your Honor, my witness being angry is part of what happened on the car ride, and why she was angry is simply providing context as to why she was feeling the emotion. Therefore, all this still fall under the scope of the question that I was asking.
I'll overrule the objection.
Ms. Montoya, did you get a chance to finish?
I did.
What did the defendant do when you were brought into their house?
Lee led me through the back entrance of her house, and after asking for a place to stay until I wasn't being followed anymore, Lee showed zero hesitation and immediately showed me to her guest house.
Thank you. No further questions, Your Honor.
Cross-examination.
Yes, Your Honor.
You may proceed.
Yes, Your Honor. Miss Montoya, I'm going to ask you some straightforward questions. If you don't understand a question, let me know. Now, let's first talk about Exhibit C and what it actually says. This is a text message conversation between you and my client dated February 14th, correct?
Correct.
In this text message conversation, Lee Croddy told you to go down to Agent Marshak's home, true?
He said I needed to get to Agent
Miss
Marshak's
Montoya,
place.
let me redirect you back to my question. Lee Croddy wanted you to go down to Agent Marshak's home, correct?
She said I needed to, correct.
But the words window don't appear in this text message conversation, true?
That's correct.
Neither do the words flash drive.
Correct.
Neither do the words download computer data, right?
She said get the documents, and I thought it would be by any means necessary,
Ms.
but
Montoya,
no.
let me redirect you back to my question. My question was, neither do the words download computer data appear in these text messages, correct?
Correct.
Neither do the words flash drive.
Objection, Your Honor. Asked and answered for flash drive.
Sustained as to flash drive.
Neither do the words steal a briefcase, true?
It was insinuated by the synonyms of getting the
Objection, Your Honor, non-responsive.
Sustained.
Motion to strike.
That's sustained.
Miss Montoya, the words steal a briefcase never appear, correct?
Not specifically, no.
And my client never said anything about punching Agent Marshak, correct?
Objection, Your Honor. Relevance. Lee Croddy is here for aiding and abetting a burglary, not assault. Therefore, whether or not Lee Croddy told Remy Montoya to punch Drew Marshak has nothing to do with the case at hand.
Your Honor, may I be heard?
Yes.
Your Honor, this is extremely relevant to the case at hand because it indicates how Remy Montoya had free will of her own. If my client didn't mention any of these things and then she pursued to do these things, it shows that Remy Montoya was not under the instruction of my client.
Your Honor, may I be heard?
Yes.
Your Honor, Lee Croddy's texts were very broad and had lots of room for interpretation. However, the case at hand and why we are all here today is whether or not Lee Croddy is aiding and abetting a burglary. At that point, it does not matter whether or not Lee Croddy told Remy Montoya to punch Drew Marshak, as that has no impact on the case or the ruling.
Oh, counsel, I'm going to disagree with you on that point. I believe that most of the actions of Montoya are relevant to the whole scope of the trial, and I'd like to know as much as possible. So your objection's overruled.
Miss Montoya, my client never said anything about punching Agent Marshak, correct?
It was never my intention to, so no, she didn't.
Miss Montoya, now let's actually talk about what you did February 15th compared to what you just testified to. Now, in fact, you did go to Agent Marshak's home, correct?
Under Lee's instruction, yes.
Objection, Your Honor, non-responsive. Motion to strike everything before yes.
Your Honor, may I be heard?
Yes.
Your Honor, opposing counsel is asking an extremely loaded question that requires context. For example, why Lee Croddy went to Ms. Marshak's house in the first place, and that is simply what my witness is providing.
I'll sustain the objection. I'll strike anything after the word yes. That's what cross-examination is for, counsel. You may continue.
Miss Montoya, you didn't stop there though, correct?
I'm sorry, can you repeat the question?
You didn't stop at simply going down to Agent Marshak's home, right?
That's correct.
You decided to look through some windows, isn't that true?
Yes, because Mrs. Marshak wasn't home.
And you decided to break into Agent Marshak's home through that window, correct?
To get the needed documents, yes.
Miss Montoya, you decided to bring your own flash drive, true?
Correct.
You decided to use that flash drive to download computer data, correct?
I knew I needed to get the things by any
Objection,
means
Your Honor,
necessary.
non-responsive. Motion to strike.
Mr. Feng?
If Your Honor believes that it is non-responsive, then that is fine.
Sustained.
Ms. Montoya, let me direct you back to my question. You decided to download computer data, true?
I did.
You decided to steal a briefcase, correct?
To get the documents, correct.
You decided to assault Agent Marshak, correct?
It was never my intention to, but yes, I did.
Now let's talk about what happened at the meet and greet. You approached my client Lee at the meet and greet, correct?
To ask for help, yes.
But while you were asking for help, you were talking fast. Isn't that true?
I believe I was talking fast, sure.
And on direct examination, you claimed that you told my client you had a run-in with Agent Marshak?
Run-in, yeah, it has a negative connotation.
Those were the specific words you used, right? Run-in.
Correct.
You never told my client you assaulted Agent Marshak.
I honestly just can't remember. I had a lot on my mind with everything that was going on.
Objection, Your Honor, non-responsive.
Overruled.
Ms. Montoya, you also claim that you told my client that you got the documents.
I said I got the stuff she needed from the house.
But you didn't tell my client that you stole the documents, correct?
Once again, I had a lot in my mind. I cannot remember everything I specifically said.
Thank you, Ms. Montoya. Now, after you had this discussion with Lee Croddy, she did not immediately take you to her home, correct?
It would have looked strange if she had just left the meet and greet.
Objection, Your Honor, non-responsive. Your Honor, I believe this witness has been non-responsive several times, and I request that the court admonish this witness.
Your Honor, may I be heard?
Yes.
Your Honor, once again, opposing counsel is not letting my witness adequately answer the question. They're not letting her provide any context. They're just cherry picking information at this point.
I have sustained objections for non-responsive responses by the witness, and I think that's sufficient. So your request for me to admonish the witness is denied. You may continue with your cross-examination.
Ms. Montoya, Lee did not immediately take you to her home, right?
No.
Lee had you wait at a public cafe, true?
Correct.
Lee had you wait with several fans surrounding you, isn't that true?
While she was talking to them, correct.
And you possessed the stolen briefcase during this time?
The government insignia'd one, correct.
In fact, you never shared the contents of the briefcase with my client at all, right?
There was never really time to between the meet and greet and going straight to bed once we got to
Ms.
leave.
Montoya, is that a yes?
It's a yes.
Now, Ms. Montoya, you believed you'd be hailed a hero for this information, correct?
With Lee stressing the necessity of everything, correct.
Finally, Ms. Montoya, you pled guilty to felony burglary, right?
Correct.
You also pled guilty to assaulting Agent Marshak, correct?
Correct.
You are facing up to 5 years in prison. Isn't that true?
I believe so.
But your sentencing will not occur until after your cooperation with the prosecution in this case, correct?
I'm just here to offer truthful testimony. I wouldn't say.
Ms. Montoya, let me direct you back to my question. My question was, your testimony and your sentencing will occur after the outcome of this trial, true?
I believe so.
Thank you. Your Honor, I have nothing further.
Thank you. Prosecution, would you like to redirect?
Yes, Your Honor. Ms. Montoya, what have you agreed to do for today's trial?
Today, I am here to just offer truthful testimony for the case at hand. I'm not here to convict or prosecute anybody.
Objection, Your Honor. Lack of foundation as to the context of truthful testimony.
Your Honor, may I be heard?
Yes.
Your Honor, the foundation was already provided by the cross-examination, specifically the last point about how Remy Montoya's sentencing will happen after and the cooperation with the prosecution.
Your Honor, may I be heard?
Yes.
Your Honor, the truthful testimony aspect of it has a lack of foundation as to what that specifically entails for this witness to testify to. It means that this witness has to testify to her memory and her experiences. Therefore, it's subjective and not rather simply truthful testimony.
Your Honor, may I be heard briefly?
Yes.
Your Honor, even if that was not true, the swearing in of the witness has also established the foundation of this truthful testimony.
Well, as the finder of fact, I'm the one who will determine what the facts are. I will determine the witness credibility. And so I'm going to overrule your objection, and we'll see, based on your argument, how persuasive I find her testimony and opinions to be.
And lastly, Ms. Montoya, how did you interpret the messages Lee sent you on February 14th?
Based on the capitalization of the word need and saying really need to get into that house, I knew I had to do it by any means necessary.
Thank you. No further questions, Your Honor.
Okay, prosecution, please call your next witness.
Prosecution would like to call Officer Max Bird to the stand.
Max Bird, are you present?
Yes, I am.
Max Bird, please raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of a mock trial competition?
I do.
Can you please state your full name and spell your last name for the record?
Max Bird, B-I-R-D.
And for your honor's convenience, the statement for this witness can be found starting on page 31 of the case packet. Thank you.
May I proceed, Your Honor?
You may.
Good morning, Officer Bird.
Good morning.
Could you tell us a little bit about your credentials?
Yes, sir. I am an officer with the Beacon County Sheriff's Station in Beacon County, California. I've been proudly protecting and serving my community for over a decade now, which classifies me as a veteran of my station.
How did you get involved in today's case?
The station received a call at 3:12 p.m. from Drew Marshak saying she had been robbed. I was patrolling nearby, so I rushed to the scene.
What did you notice about Mrs. Marshak when you arrived?
I saw Mrs. Marshak in a daze and with multiple injuries. She had a wound to the face and a large gash on her forehead.
What, if any, information did Mrs. Marshak give you about the robbery?
Mrs. Marshak seemed distraught, but she did give me a physical description of the perpetrator and informed me that the perpetrator stole her briefcase, which contained confidential government information.
What did you do with this information?
The station sent out a police sketch with the description of the perpetrator, and the next morning, we received a tip from someone claiming to see the suspect at the defendant's house, which prompted me to go to the residence.
Objection, lack of foundation as to how they identified it as the defendant's house.
Counsel?
Your Honor, I can lay some foundation. Yeah.
Objection sustained.
Officer, when did you find out that it was the defendant's house?
In the tip that we received, the address that was provided was the residence that I went to, and then later, after going to the house, the defendant identified herself as Lee Croddy, and that's when we knew it was the defendant's house.
Thank you. What important events occurred at the scene?
Well, I recognized the perpetrator from the police sketch. She was pacing across the defendant's yard. She identified herself as Remy Montoya, and I placed her under arrest.
What, if anything, did she say to you?
She was saying to join a revolution and to join us as she nodded towards...
Hearsay.
Your Honor, may I be heard?
Yes.
This would fall under the hearsay exception of excited utterance, as this is taking place while Remy Montoya is under arrest, which would be a stressful event for anyone.
May I be heard, Your Honor?
Yes.
For an excited utterance exception, the statements made by the declarant need to be in relation to the event that caused the stress or excitement. The statements that Remy Montoya made at this time are in no way related to the arrest that was the excited event, and thus that these statements do not fall under the excited utterance hearsay exception.
Your Honor, may I be heard?
Yes, and let's backtrack exactly. Where are we at which point, and what's the statement that you're trying to get in? I'm sorry.
The statement was that Remy Montoya asked Officer Byrd to join a revolution and join us. And this would still fall under an excited utterance objection, as to Remy Montoya's knowledge, she believed she was being arrested for the events that she claimed were the revolution. And also, it would also go to show the state of mind of Remy Montoya at the time of the arrest, as it shows the motive for why she committed any any activities before this.
The objection's overruled.
Do you need me to repeat the question, Officer Byrd?
Yes, please.
What, if anything, did she say to you?
Montoya was saying to join a revolution and to join us, as she nodded towards the defendant's house.
What other interaction did you have with Remy Montoya?
After questioning Montoya, she revealed that it was the defendant who provided Montoya
Objection,
with...
hearsay.
May I be heard?
Yes.
This statement goes towards the state of mind of Remy Montoya, as it goes to show what she was thinking when the defendant told her to get into the house.
So is it being admitted for the truth of the matter, or what?
It is under the hearsay exception of state of mind.
Right.
May be heard, Your Honor.
Yes.
Remy Montoya's state of mind at the time that they made this statement is not relevant to the case at hand.
I'll allow it for now, and after the witness has completed their testimony, I'll entertain a motion to strike.
Did you get a chance to finish your answer, Officer Byrd?
No, sir, I did not, but I can continue. After questioning Montoya, she revealed that it was the defendant who provided Montoya with Marshak's address and instructed her to go into Marshak's house and get the papers.
What, if any, interactions did you have at the site of the arrest besides the one with Remy Montoya?
The defendant came out of her house and asked, "What did Remy do?" And interestingly, what did Remy take?
Why was this interesting to you?
Well, I had not informed the defendant of any burglary yet, so her suspicion
Objection,
of theft...
relevance as to why this officer would find a statement my client made interesting.
Your Honor, may be heard?
Yes.
This is interesting because it goes to show why, or this is relevant because the interestingness of the statement goes to show why the officer had suspicion of the defendant and led to the arrest of the defendant later, as will be shown in further questions.
May be heard, Your Honor.
Yes.
This officer's testimony as to why they suspected Lee Croddy, or at what point that suspicion started, is an improper opinion. This assumes the guilt of Lee Croddy, and that is a determination for this court to make, not this witness.
Your Honor, may be heard?
Yes.
Suspicion of a witness is something that a officer is perfectly qualified to have. As an officer, they must suspect a witness or suspect a person in order to arrest them. Just because they suspect them or arrest them does not mean they are guilty. It simply shows to why the officer arrested or suspected, which led to the arrest of Lee Croddy.
I'll overrule your objection. It's going to the really goes to the weight and not the admissibility. So I'll determine just how relevant it is in my determination of the verdict. But I don't mind hearing it. Go on.
Officer, did you get a chance to finish your answer?
No, I did not, but I will continue. At this point, I had not informed the defendant of any burglary yet, so her suspicion of theft was very interesting to me.
What other evidence led to the arrest of Lee Croddy?
After conducting interviews with both Zuri O'Neill and Erin Sullivan, I considered Miss Croddy a suspect. I then gathered further information before arresting the defendant and charging her with aiding and abetting a first-degree burglary and accessory after the fact.
Thank you. No further questions at this time, Your Honor.
Cross-examination?
Yes, Your Honor, but before I begin, may the defense request a time check?
Yes.
Of course, the defense has 4 minutes and 25 seconds remaining for cross-examinations.
Thank you. Good morning, officer.
Good morning, ma'am.
Let's talk about what happened on February 16th. You arrested Remy Montoya, correct?
That's correct, ma'am.
And you arrested them at the residence of whom you later identified as Lee Croddy. Isn't that true?
Yes, that's true.
And when you arrived at the residence, Montoya was pacing, correct?
Yes, she was pacing across the yard.
And they were in plain sight?
Yes, that is also true.
At this moment in time, Montoya wasn't hiding, were they?
It didn't seem like it, no.
And during this time, the arrest, Montoya was causing quite a commotion, weren't they?
Yes, she was saying to join a revolution, yelling, and that's correct.
And they were acting frantic, you would say?
Yes, she seemed extremely frantic.
And during that commotion, Lee Croddy came outside of her home, true?
Yes, that's true.
She asked you, what did Remy do?
Along with what she took, yes.
That wasn't my question. I'll ask it again. Lee Croddy asked you, what did Remy do, correct?
Yes, that's correct.
Now, after this, you asked Lee a few standard questions, correct?
Yes, including how she knew Montoya.
And Lee Croddy admitted that Montoya had stayed the night at their home. Isn't that true?
Yes, that's true.
Lee Croddy showed you the room where Montoya was staying that night?
Only after I asked, but that's true.
And Lee even agreed to accompany you to the station for further questioning. Isn't that true?
I asked her.
Your Honor, this is outside. This is an unfair extrapolation, as these materials were not allowed because of the pretrial motion.
May be heard, Your Honor.
Yes.
If you go to page 32, lines 23 to 25, it states, I asked Croddy to accompany me in the unmarked vehicle down to the station for further questioning. This is before the bracketed evidence that my esteemed opposing counsel is referring to that was excluded in the pretrial motion, and thus making it not an unfair extrapolation because that those lines are before that bracketed information.
Anything further, counsel?
Your Honor, if opposing counsel limits this testimony to just that simple sentence, then I withdraw my objection.
Okay. It's the statements that were suppressed. Certain actions were not. So the objection is overruled. You may proceed.
Sorry, did you get to say your answer?
No, I did not, ma'am, but could you please repeat the question?
Of course. Lee agreed to accompany you to the station for further questioning. Isn't that true?
After I asked, that is true.
And finally, when you went to arrest my client a week later, Lee Croddy calmly complied with your instructions, right?
Objection, Your Honor, relevance.
Counsel?
Yes, this is relevant as it goes to the state of mind of the defendant, as well as their presumed their compliance with the police goes to their credibility and their innocence as a defendant.
The objection is overruled.
Let me ask the question again. Finally, when you went to arrest my client a week later, Lee Croddy calmly complied with your instructions, correct?
Ma'am, I was arresting her, so yes, she did comply with my instructions.
The answer is yes?
Yes, that's correct.
Thank you, Your Honor. No further questions for this witness.
Redirect?
None, Your Honor. May this witness be excused?
Yes. You may call your next witness.
Your Honor, before we begin, the prosecution would like to request a time check.
Of course.
The prosecution has 5 minutes and 55 seconds remaining for direct examinations, and the defense has 2 minutes and 20 seconds remaining for cross-examination.
Thank you. The prosecution calls Zhou Marshak to the stand.
Zhou Marshak, are you present?
Yes, I am.
Zhou Marshak, please raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Can you please state your full name and spell your last name for the record?
Yes, Zhou Marshak, M-A-R-S-H-A-K.
And for your Honor's convenience, the statement for this witness can be found starting on page 29 of the case packet. Thank you.
Yeah.
Your Honor, may I proceed?
You may.
Good morning, Mrs. Marshak. Can you please introduce yourself to the court?
Yes, I'm Zhou Marshak. I'm 42 years old, and I've been an investigator with the California State Department of Justice's Bureau of Investigation for over 15 years.
Can you briefly explain what your work at the Bureau entails?
It involves the collection and analysis of time-sensitive, confidential material. That's about all I can say.
Mrs. Marshak, I'm going to ask you now about the events that took place in your home on February 15th. What of any importance happened that afternoon?
I got home at around 3 p.m. and noticed that my side gate was slightly open. I wasn't too worried about it because I occasionally leave it unlocked for my gardener, so I just walked through the front door.
What happened after you entered your home?
I saw that there were faint, muddy footprints in the entryway, and then I saw someone sitting in my sitting room. I didn't know who it was or why they were here. All I knew was they were coming toward me. It wasn't until after the incident that I learned that this person was Remy Montoya.
What was your reaction to seeing Ms. Montoya in your home?
I tried to stop her, but she attacked me. She punched me across the face, and I lost my balance. I fell and hit my forehead on my coffee table.
How did you feel after hitting your head?
I felt dizzy and confused, but I vividly remember looking up at the intruder standing over me, holding my state-issued briefcase. She looked just as terrified as I was.
I'm sorry to hear that, Mrs. Marshak. If I may continue, I'd like to direct your attention to Exhibit A. Do you have Exhibit A on hand?
Yes.
Do you recognize the object shown in this exhibit?
Yes, that's my state-issued briefcase. It's the one that Remy Montoya took from my house. It's engraved with my first initial, full last name, and a large insignia on the front. I'd know it anywhere.
Is this a fair and accurate representation of your briefcase?
Yes, it is.
Your Honor, permission to move the briefcase into evidence as Exhibit A?
Is it the briefcase or a photo?
Photo of the briefcase.
Any objection?
No objections, Your Honor.
All right, it's admitted.
Mrs. Marshak, what, if anything, did you hear Ms. Montoya say while standing over you holding this briefcase?
I remember her saying, "Oh no, what have I done? What am I doing?" She also muttered, "Lee is not going to like this, and at least we got the proof we needed."
What happened next?
I went to the hospital and was later questioned by a police officer. Throughout this whole time, I just felt so helpless, angry, and terrified. I've always been on the other side of these investigations. I've tried to keep my work life separate from my family life.
Lastly, what else, if anything, did you hear Ms. Montoya say as she fled the scene?
Before she ran out the door, I remember Remy took one last look back at me.
Objection, Your Honor. Hearsay.
Your Honor, may I be heard?
Yes.
Your Honor, these statements, like the previous ones by Remy Montoya, fall under the hearsay exception of excited utterance. As Ms. Mrs. Marshak has previously testified, Ms. Montoya was clearly under stress at the time of the incident, and that continues out as she flees the scene.
Anything further? Anything further, Jasmine?
No, Your Honor.
I'm sorry, Mariah, in regards to your objection.
I will withdraw the objection if it falls under this limited exception of excited utterance, Your Honor.
Okay. The objection's withdrawn. You may continue.
Mrs. Marshak, did you get a chance to finish your response?
No, I didn't.
Would you like to repeat the question, or are you prepared to continue?
I'm prepared to continue. Before Remy ran out the door, I remember she took one last look back at me and quickly said, "I'm so sorry. I didn't mean to. I had to do it. I had to do it. This is for the people."
Thank you, Ms. Marshak. No further questions. Your Honor.
Pardon?
Oh, sorry.
Cross-examination.
Yes, Your Honor.
You may proceed.
Good morning, Ms. Marshak.
Good morning.
On the night of February 15th, Remy Montoya was in your house, correct?
Yes, that is correct.
And Ms. Montoya was alone?
Yes.
It was Miss Montoya who had your briefcase, correct?
That is correct.
And then Miss Montoya punched you in the face, true?
That is true.
2 minutes.
And it was at this point that she said, "What have I done?" Correct?
Yeah, it was almost like she wasn't in control of her actions.
Followed by, "Lee is not going to like this," correct?
I thought it was weird that she mentioned this third person, Lee, while robbing me.
Objection, Your Honor, non-responsive.
Sustained. The answers. Well, would you like to respond by the people?
Your Honor, the witness can be allowed to, the opposing counsel we can repeat the question.
The objection is sustained. The answer is stricken.
Ms. Marshak, Remy said Lee is not going to like this, correct?
That is correct.
Thank you. No further questions, Your Honor.
Redirect?
Yes, Your Honor, briefly. Mrs. Marshak, when Remy Montoya mentioned this third person, Lee, what did you make of it?
I thought it was kind of weird that she had mentioned this person, Lee. It was almost like somebody had
Objection, Your Honor, relevance.
Your Honor, may be heard.
Yes.
Your Honor, Remy Montoya's statements as to Lee are involved in this case because they go to show Remy Montoya's state of mind at the time of the incident, and therefore Mrs. Marshak's testimony to them is also relevant.
May I be heard, Your Honor?
Yes.
While I agree that the statements are relevant, I believe that Ms. Marshak's opinion as to the statements are not relevant to this case.
I agree with her opinion not being relevant, but it's the statement that I'm focusing in on. So I'm going to overrule your objection.
Mrs. Marshak, did you get a chance to finish?
No, I didn't. Would you mind repeating the question?
Yes. When you heard this statement about Lee, what did you make of it?
I thought it was almost like Lee had instructed Remy to...
Wait a minute. I agree. I'm going to reverse my ruling. Her opinion's not relevant. It's the statement. So I'm going to sustain the objection.
Motion to strike the witness's answer, Your Honor.
And the answer is stricken.
No further questions, Your Honor. May this witness be excused?
Yes. Please call your next witness.
The prosecution would like to call Dr. Kai Chavez to the stand.
Dr. Kai Chavez, are you present?
Yes.
Dr. Kai Chavez, please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of a mock trial competition?
I do.
Can you please state your full name and spell your last name for the record?
Kai Chavez, Chavez.
And for your honor's convenience, the statement for this witness can be found starting on page 34 of the case packet. Thank you.
Before I begin, may I request a time check for the prosecution?
Yes.
Prosecution has 2 minutes and 30 seconds remaining for direct examination, and the defense has 1 minute and 35 seconds remaining for cross-examination.
Excuse me, I'm the unofficial time clerk, and I've noticed a time discrepancy, and according to the rule book, if there's a significant time discrepancy that is greater than 15 seconds, it must be addressed to the court. So I have a total of 1 minute and 49 seconds remaining for the direct examination, and I've been checking this time and making sure it was correct during the whole trial. So I would like to discuss with the time clerk to resolve this issue.
You're saying 1 minute, 49 seconds left for what?
For the direct examination of witness 3.
And what's the official saying?
For cross-examination of witness 3.
Whatever. She says 1 minute, 49 seconds left for direct examination. What is your calculation?
2 minutes, 30 seconds.
And you two would like to converse to determine if you can reconcile this discrepancy.
Yes. Would you like us to do it in the Zoom or in the private chat?
Private chat.
Okay.
And we're stopping the proceedings while you check this. Is that correct?
Yes, Your Honor. So, I have been discussing with the official time clerk, and we can't seem to decide what should be. I am proposing to just split the time in half and take the time difference that we had of about 3 seconds and just add 20 seconds to the time I got, or subtract 20 seconds to the time that the official clerk had recorded.
So there's a 40-second discrepancy, is that it? 41 seconds.
Yes, there is a discrepancy.
All right. And how do you feel about that, Joshua?
I believe that I was keeping accurate timing, and multiple teammates have also been timing, and they've gotten similar results to me.
Once again, Your Honor, I'm not claiming that the clerk is not able to time. I am just stating that in order to not further delay the trial and to be able to keep an even playing field, we just split the time and add the extra time difference, Your Honor.
All right, I'm going to allow that for the sake of fairness. We'll split the baby, so to speak. So the unofficial timer, how much time are you requesting, or what are you requesting the time be set at?
I will just add 20 seconds to my time, which would be 2 minutes and about 10 seconds.
All right. That'll be the order of the court.
Oh, along with this, I just wanted to state that clerks are not permitted to converse what times they got with other team members, and I don't know which.
It was a given time discrepancy, and we were just checking whether who was right or wrong. Clearly, one of us is right and wrong, and it's unfair to split time and take away time from the prosecution.
Well, I'll leave it to the scorers to determine if there's been a rule violation by any communication among team members. And I have made a ruling where I am giving more time than the unofficial timekeeper believes is appropriate, but I'm not giving all of the time, or I'm not giving her everything that she wants. So.
Thank you, Your Honor. My apologies for the delay.
So 2 minutes, 10 seconds remaining is your position for who?
For the direct examination.
All right. 2 minutes and 10 seconds remain for direct examination by the prosecution.
Yes.
Okay.
May I proceed, Your Honor?
You may proceed.
Good morning, Dr. Chavez.
Good morning.
Let's begin with your qualifications. Could you tell us a bit about your education?
Sure. In 2004, I earned my bachelor's degree studying psychology at the University of South Hudson, and then went on to pursue a master's degree in 2011 with 3 years of residency.
What kind of work do you do now?
In my private practice, I prescribe medication and provide psychotherapy to patients with various psychiatric illnesses. I have also served as an expert witness in about 150 cases.
Now, let's move on to your assessment of today's case. To start, could you describe the concept of groupthink to the court?
Sure. Groupthink is when certain groups value conformity, limiting individual decision-making. This is often seen in fan bases like what the defendant has online. This can create an environment that can lead to disastrous consequences.
How does groupthink apply to the case at hand?
In the group chat, it's clear that the toxic environment the defendant established directly influenced the fans' individual behavior.
1 minute.
Could you explain how the defendant contributed to the creation of this dangerous environment?
The defendant went on long, angry rants on their YouTube channel and spoke out against the government, even making
Objection, Your Honor, improper.
Your Honor, may I be heard?
What was the complete objection?
Improper opinion, Your Honor.
Your response, counsel?
Your Honor, according to the mock trial simplified rules of evidence, improper opinion only applies if the expert either does not have the proper qualifications or if they are attempting to testify to the defendant's mental state. Neither of these are applicable to the statement, as the defendant or the witness laid out their qualifications and is not in any way attempting to testify to the defendant's mental state at any point in time.
The objection's overruled. Again, I want to hear a little bit more. Maybe I'll entertain a motion to strike afterward.
Dr. Chavez, did you get a chance to answer your question?
No, not fully. Could you repeat it?
Could you explain how the defendant contributed to the creation of a dangerous environment?
The defendant went on long, angry rants on their YouTube channel and spoke out against the government, promoting a hostile environment for their fans, as well as even making direct calls to action against Drew Marshak in the group chats, making a clear groupthink environment that
30 seconds.
Individual decision-making.
And in your professional opinion, what role did the defendant play in Remy Montoya's actions?
In my professional opinion, the defendant's establishment of a toxic environment that encouraged criminal behavior makes her a puppet master who is responsible for Remy Montoya's actions.
Objection, Your Honor. Improper opinion as to puppet master.
Your Honor, may I be heard?
Yes.
My argument still stands from the previous objection that we have laid out the witnesses' qualifications, and they are not attempting to testify to the defendant's mental states, but simply how their actions affected other people in the group chat's mental states.
I am a bit concerned with this expert's ability to testify as to another individual's thought process. So I'm going to sustain the objection.
Motion to strike that portion of the witness's answer, Your Honor.
Granted.
Dr. Chavez, in your opinion, is Lee Croddy partially responsible for Remy's actions?
Yes, definitely. His manipulative and toxic tactics make him partially responsible for Remy's actions.
Objection, Your Honor. In proper opinion, I believe this witness is still testifying to my client's mental state.
Your Honor, may I be heard?
Yes.
This is not testifying to the defendant's mental state. It's simply testifying to the doctor's, after the doctor has gone through all the materials, they believe that that with the materials given, Lee Croddy has somehow contributed to Remy Montoya's mental state. There's nothing about Lee Croddy's mental state or whether it was even on purpose, but simply that it happened.
May I be heard, Your Honor?
Yes.
Witness did not testify to Remy Montoya's mental state. She testified to Lee Croddy's manipulation and how it applies to these actions taken.
Your Honor, may I be heard?
Yes.
My witness was testifying to the fact that Lee Croddy's actions created an online toxic environment filled with groupthink. This clearly has nothing to do with the defendant's purpose or the defendant's mental state, but simply how the action affected her fans in her online environment.
Now, this doesn't relate to Croddy's mental state. This isn't an opinion in regards to Montoya's mental state. Is that fair to say?
That is the prosecution's position, Your Honor.
All right, I'm going to allow it in since it's not directly related to the defendant's state of mind.
Thank you. Your Honor, I have no further questions at this time.
Cross-examination.
Yes, Your Honor. Before I begin, may I request a time check?
The defense has 1 minute and 35 seconds remaining for cross-examination.
Thank you. Good morning, Dr. Chavez.
Good morning.
Doctor, you examined a Twitter group chat in this case, correct?
Yes, that's correct.
And in this group chat, there were a total of 7 participants, true?
I do believe that's true.
And you believe that this group chat can be described as an example of groupthink, correct?
Yes, definitely. The defendant definitely did establish that kind of toxic environment.
Doctor, the group chat can be described as an example of groupthink, correct?
Yes, as I said, yes.
Therefore, all 7 members would be influenced by groupthink, correct?
Yes, that's correct.
However, I'd like to direct your attention to Exhibit B. Do you have this exhibit?
Yes, I do.
In this exhibit, we see Lee in line 36 to 38 stating where we have to march up to this Marshak person, demand answers, correct?
Yes, not verbatim, but that's correct.
And further down in line 44, we see Chris responding with, we'll all be there, true?
Yes, that's correct.
However, out of all 7 members of this group chat, Remy Montoya was the only one who went to Agent Marshak's house on the night of February 15th, correct?
30 seconds.
And he's the only one who stole confidential documents from Agent Marshak, true?
Yes, under the direction of Lee after having a one-on-one.
Doctor, he is the only one who stole confidential documents, true?
As I said, correct.
And he is the only one who assaulted Agent Marshak?
Yes, that's correct.
Thank you. No further questions, Your Honor.
Redirect?
None, Your Honor. May this witness be excused?
Yes. Is that the last prosecution witness?
Yes, at this time the prosecution rests.
Okay, all right. Is the defense ready to proceed?
Yes, Your Honor. The defense calls Dr. Jes Beeart to the stand.
Dr. Jes Beeart, are you present?
I am.
Dr. Jes Beeart, please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Can you please state your full name and spell your last name for the record?
Yes. Jes Beeart, Beaart.
And for your honor's convenience, the statement for this witness can be found starting on page 44 of the case packet. Thank you.
May I proceed, Your Honor?
You may.
Good morning, Dr. Beeart.
Good morning.
Doctor, could you tell the court about your professional credentials?
Yes. I graduated from Peterson University with a bachelor's degree in sociology and marketing and a minor in psychology. I pursued my PhD in sociology, and now I'm an associate professor at Beechwood University, focusing in sociology, and I continue to conduct research on social movements.
And how did you become involved in this case?
Well, I was tasked with forming an independent opinion whether Remy Montoya and Lee Croddy follow the pattern of online activism that I've studied in the past.
And what research did you consider to reach an opinion?
Well, I considered the opinion of Dr. Chavez, exhibits B and C, along with my research as applied to the witness statements and exhibits in this case.
Can you tell the court about some of your research?
Yes. I published an article in a peer-reviewed sociology journal analyzing how social movements adjusted to the global coronavirus lockdown. I focused primarily on what made these movements switch successfully to social media.
Have you seen movements switch successfully to social media?
Yes. I saw environmental activism take on a new life online. One of the first examples of online activism was when 15-year-old Greta Thunberg started the movement School Strike for Climate. This started the hashtag School Strike for Climate, which was inspired by Thunberg.
And how is this different from in-person activism?
Well, online activism allows for people like Thunberg to be the kind of activist that sees themselves as a catalyst for a movement, not as the leader of an organization that will direct the actions of the movement.
And what is your opinion in this case?
After considering exhibits B and C, I concluded that Remy Montoya's behavior is consistent with someone who acted independently of an online influence. I also concluded that Lee Croddy's actions as an online activist are consistent with a traditional online activist like Greta Thunberg.
Thank you, Doctor. I'd like to ask you now about specific individuals in this case. Are you aware of Dr. Chavez's opinion with respect to groupthink?
Yes. I'm aware of Dr. Chavez's opinion. I'm aware of Dr. Chavez's opinion regarding that Remy Montoya was subjected to groupthink.
And do you agree with Dr. Chavez?
I do not agree with Dr. Chavez.
Why do you disagree?
Well, from what I can tell from Dr. Chavez's opinion, groupthink is an idea that traditionally limits freedom of thought and makes it very difficult to make individual decisions. However, since Remy Montoya was the only one out of the group chat who acted on their words, it is my expert opinion that groupthink is not at play here.
Thank you. I'd like to direct your attention now to Exhibit B. Do you have this exhibit?
I do, yes.
What in this exhibit told you this?
Well, looking especially towards line 23 and 24, we see that Remy Montoya replied to Lee very similarly to the other members of the group chat. However, since Remy Montoya was the only one who acted on their words, it is my opinion that groupthink is not at play here.
If not characterized by groupthink, how would you characterize Remy's actions?
Well, it is my expert opinion that Remy Montoya's criminal activities were committed independently. Remy Montoya's behavior is consistent with a fanatic fan of an online personality.
Now, directing your attention to Exhibit C, do you have this?
I do.
What from Exhibit C influenced your opinion?
Well, in Exhibit C, we see Lee calling for legal action from Remy. It is my opinion that Croddy was directly calling for action. However, their calls for action were not for illegal action, simply to take legal and direct.
Thank you. No further questions for this witness, Your Honor, at this time.
Cross-examination.
Yes, Your Honor. Good morning, Dr. Beeart.
Good morning.
In direct examination, you compared the defendant to Greta Thunberg, is that correct?
I did, yes.
And you have testified before that Thunberg, like the defendant, in your opinion, is a catalyst for action rather than someone who directs the action of others, correct?
Yes, of movements.
And directing the action of others can be defined as explicitly telling someone to perform a task. Would that be correct?
Yes, you could say so.
Now, Dr. Beeart, do you have what has been previously entered as Exhibit C?
I do, yes.
And is this a fair and accurate representation of the WhatsApp conversation as you've seen it?
I believe so. This was the exhibit that I was provided with.
Now, lines 29 through 31 contain a message from the defendant, correct?
Yes.
And lines 29 through 31 read, "We need those documents, Remy. You really need to get into that house tomorrow." Is that correct?
Yes.
Now, the defendant here sent a message telling Remy to get into Drew Marshak's house, correct?
Are you referencing a line or just the content of the exhibit?
Just in this message specifically, lines 30 through 31.
Mm-hmm. Could you repeat your question? I'm so sorry.
Yeah. The defendant sent to this message, told Remy to get into Drew Marshak's house, correct?
Yes, get into the house.
And also, the only word in this message that the defendant wrote in all capital letters was the word need, right?
Yes, that's true.
Now, you agreed earlier that personally instructing somebody to get in to perform an action is direct action, right? Directing action.
Objection, Your Honor, vague.
Overruled.
Could you repeat your question, counsel?
Yes, you agreed earlier that telling someone to do a certain task would be directing action, right?
Yes.
And personally instructing somebody to get into another person's house, then by your definition would be directing action, right?
Yes, that's true.
And so does that would take away from your comparison of Greta Thunberg comparing to the defendant, as clearly the defendant is directing action in this scenario, right?
Objection, argumentative.
No, this is not argumentative. I'm simply asking for a clarification of their beliefs now that they have agreed to seemingly contradictory ideas.
The objection's overruled.
I'm sorry, could you repeat your question, counsel?
Your definition of directing action would break with your comparison that both Greta Thunberg and Lee Croddy do not direct the action of their followers, correct?
I don't believe so, no.
You testified that telling somebody to get into a house is directing action, right?
Yeah.
And you testified that Lee Croddy sent a message telling Remy Montoya to get into another person's house, correct?
Objection, Your Honor, asked and answered.
Your Honor, may I be heard?
Yes.
I'm again asking for clarification as she is contradicting her previous answers that she's given in this testimony.
The objection's overruled.
Do you need me to repeat the question, Dr. Beeart?
Please.
You agreed that the defendant sent a message directing Remy Montoya to get into Drew Marshak's house, right?
Yes.
But you do not agree that the directing action in this case would mess with your definition that Greta Thunberg and Lee Croddy do not direct action?
I'm sorry, I think I might be not understanding your question properly.
I can rephrase, I'm sorry.
Please.
You say that Greta Thunberg and Lee Croddy are similar in that they do not direct the action of their followers, yet you just testified that Lee Croddy directed the actions of Remy Montoya.
Objection, Your Honor, compound.
Overruled.
I'm sorry, I don't recall testifying that Lee Croddy never directed action.
At the beginning of this testimony, you agreed that you compared Greta Thunberg to Lee Croddy because they were catalysts for action rather than someone who directs the action of others. That testimony can also be found on page 45 of the case packet. Lines, I apologize, let me find a line number. You stated that, I'm sorry, let me pull up the statement specifically, that Thunberg, like the defendant, is a catalyst for action rather than someone who directs the action of others.
I see. I'm afraid excuse me. I'm afraid I misinterpreted your question.
Which question did you misinterpret?
I believe that I may have misinterpreted the one regarding that Lee Croddy was directing action.
The one that you agreed to multiple times, saying that Lee Croddy in this message directed his followers to go to Remy Montoya's house? Or,
Yeah.
I'm sorry, to Drew Marshak's house?
Yes, I believe I might have misinterpreted you, and my sincerest apologies.
Thank you. No further questions, Your Honor.
Redirect.
Briefly, Your Honor. Dr. Beeart, why did you compare Lee Croddy to Greta Thunberg?
Well, Lee Croddy and Greta Thunberg both have very similar styles of an online presence as an online activist. Their actions are very similar.
And what is a catalyst for a movement?
Well, a catalyst for a movement is someone who essentially becomes...
Objection, Your Honor. No, I'm sorry. I withdraw my objection.
You may answer. Come on.
I'm sorry, could you repeat your question?
What is a catalyst for a movement?
Well, a catalyst for a movement is someone who essentially becomes the face of the movement, inspiring actions from their followers.
Now, redirecting your attention to Exhibit B.
Yes.
Opposing counsel asked you questions about some of Lee's statements.
Objection, Your Honor. Exhibit B is outside the scope of cross-examination.
Did you ask about Exhibit B during your cross?
No, I never did, Your Honor.
He asked about statements in Exhibit B that said, get into that house.
Your Honor, those statements were within Exhibit C, not Exhibit B.
My apologies, I meant Exhibit C. Doctor.
Rephrase, continue.
Doctor, do you have Exhibit C in front of you?
I do, yes.
Now, you were asked about statements that say, get into that house. Why did these statements not influence your opinion differently?
Well, for one, I had already reviewed these exhibits, and these statements called for legal action from Remy.
Thank you. No further questions for this witness, Your Honor. May she be excused?
Yes. Call your next witness, please.
The defense calls Zuri O'Neill.
Zuri O'Neill, are you present?
I am.
Zuri O'Neill, please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Can you please state your full name and spell your last name for the record?
Zuri O'Neill, Oneill.
And for your honor's convenience, the statement for this witness can be found starting on page 41 of the case packet. Thank you.
Before I begin direct examination, may I request a time check?
The defense has 9 minutes and 10 seconds remaining for direct examination, and the prosecution has 6 minutes and 30 seconds remaining for cross-examination.
Thank you. Good morning, Miss O'Neill.
Good morning.
What do you do for a living?
Currently, I'm an intern at Atlantic News Nightly.
Are you familiar with my client, Lee Croddy?
Yes, I'm familiar.
How so?
I'm a follower and a huge fan of Lee's YouTube channel, The Right Choice of News, and I'm also a part of a private group chat on Twitter with Lee and 5 other followers, including Remy Montoya.
Why did you become a fan of Lee Croddy?
I just loved that Lee was so passionate about freedom, and she was such a straight shooter when it came to uncovering the truth.
unlike some of the other fake personalities that I would watch online.
How would you characterize the conversations had in the group chat you were in?
I would just say it was harmless venting between some online friends.
Objection, Your Honor, speculation.
I'm sorry, what was your objection, counsel?
Speculation as to the harmless venting in the group chat. Zuri cannot read the minds of other people in the group chat, and therefore, maybe to her it was harmless venting, but to other people it wasn't. She has no way of knowing that, therefore it is speculation.
Counsel, your response?
Yes, she has personal knowledge of the group chat, and my question asked for her to characterize the conversations had in the group chat from her perspective. She would definitely have personal knowledge of the interactions in the group chat, given that she was in the group chat, and she would be able to testify to her characterization of those text messages.
The objection's overruled.
Let's talk about what happened on February 12th. Was there any activity on the group chat that day?
Yes, we were all texting on the group chat that day.
What about?
Lee had sent us the sneak peek of the video that she was planning to post the following day about the government hiding evidence of UFOs from the public.
Did Lee post anything else?
Yes, Lee had posted some passionate language about taking what is ours from Agent Marshak if she didn't give us answers.
Objection, hearsay.
Counsel, your response?
Yes, Your Honor. The statement about taking what is ours from Agent Marshak if he didn't give us answers is not hearsay because we are not offering it for the truth of the matter asserted. In fact, the defense is trying to prove the exact opposite of what it's asserting. The defendant did not want anybody to actually take anything from Agent Marshak. We are showing that the defendant's statement is harmless venting and not a call to action. Hence, this is not hearsay.
The objection is overruled.
How did you interpret Lee's post?
I would say it's the same harmless venting you would see on our group chat. It really wasn't a big deal.
Let's now move forward to February 15th. Did you meet Lee that day?
Yes, at the meet and greet. This was before the pandemic, so it was live and in person, and I had so much fun.
Who else besides Lee did you see at this meet and greet?
Well, of course, a ton of Lee's followers were there, and Remy Montoya from our group chat was also there. I recognized her from her chat profile online.
Did you see Lee and Remy Montoya interact at all during the meet and greet?
Yes.
Your Honor, this question is leading.
Overruled.
I'm sorry, did you just say your answer?
Yes, I said yes.
And did Remy leave the meet and greet right after you saw them interact?
Actually, no. Remy was still there along with some other fans after I had left the meet and greet.
Thank you. Your Honor, no further questions for this witness at this time.
Cross-examination.
Yes, Your Honor. Good morning, Ms. O'Neill.
Good morning.
Let's start by talking about the group chat. The address of Zhou Marshak was visible in the sneak peek sent to the group chat on February 12th, correct?
In the sneak peek, yes.
And in the final video, Lee directly calls for the viewers to demand information from Zhou Marshak. Isn't that true?
Yes, she did.
And lastly, in your opinion, Lee Croddy's words leave very little room for interpretation. Isn't that true?
Well, with her work on her YouTube channel.
I'm sorry, Ms. O'Neill, is that a yes or a no?
That was a yes.
Thank you. No further questions, Your Honor.
Redirect.
Yes, Your Honor, briefly. Ms. O'Neill, what context did you mean when you said that Lee's words meant had little room for interpretation?
Well, I only knew Lee in the context of her work with RCN and uncovering government lies, so that was what I meant by the context of her work with her YouTube channel.
Thank you. No further questions, Your Honor. May this witness be excused?
Yes. Please call your next witness.
The defense calls Erin Sullivan to the stand.
Erin Sullivan, are you present?
Yes.
Erin Sullivan, please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of a mock trial competition?
I do.
Can you please state your full name and spell your last name for the record?
Erin Sullivan, Sullivan.
And for your honor's convenience, the statement for this witness can be found starting on page 46 of the case packet. Thank you.
Before I begin, Your Honor, may I request a time check?
Yes.
Of course, the defense has 6 minutes and 35 seconds remaining for direct examinations, and the prosecution has 6 minutes remaining for cross-examination. The defense has 6 minutes, 35 seconds remaining for direct examination.
Thank you. Good morning, Ms. Sullivan.
Good morning.
What do you do for a living?
I'm Lee Croddy's agent and have been for 3 years.
And what do you do for Lee as Lee's agent?
I do it all. I set up events for Lee, act as a liaison with Lee's publicist, and I work with the legal and business side of her brand.
What sort of work do you do with the legal team?
Well, one thing the legal team and I does is to help ensure that Lee's videos promote responsible behavior. For example, we work to put a legal disclaimer at the beginning of each YouTube video to inform the viewers that the video content should be used for educational and discussion purposes only.
And have you seen Lee interact with her fans?
Yes, many times.
When?
Many times at social events, I've seen Lee interact with her fans. Of course, this was before the whole pandemic when we could meet in person without masks or social distancing.
And from these interactions, have you been able to form an opinion as to Lee's character for treating her fans kindly?
Yes, I have.
And what is this opinion?
Well, Lee is one of the kindest people that I know. Even though she's a celebrity, she treats her fans like friends. It doesn't matter if they're a longtime viewer or a new fan. Lee always goes above and beyond for her fans.
Thank you. Shifting gears, Ms. Sullivan, do you know Remy Montoya?
Yes, Remy is one of Lee's fans. I was introduced to her at a meet and greet event.
What was Remy doing at this meet and greet event?
Well, I saw Remy and Lee embracing, and then Lee took Remy over to a nearby table. I noticed that Remy was pacing around the cafe throughout the entire event.
And what did Lee do next?
Well, Lee waited until after the meet and greet was over before taking Remy back to her house to calm down.
And from what you have seen, was this behavior abnormal for Lee?
No, Lee is always going above and beyond for her fans.
Thank you. No further questions at this time, Your Honor.
Ross?
Yes, Your Honor. Good morning, Ms. Sullivan.
Good morning.
Ms. Sullivan, as an agent, your reputation in your field is directly tied to the success of your clients. Is that correct?
Yes, you could say that.
Lee Croddy is a very prominent client of yours, correct?
Unfair extrapolation. Objection, Your Honor. Unfair extrapolation.
Your Honor, may be heard.
Yes.
Your Honor, this is not an unfair extrapolation. Ms. Sullivan has testified in her witness statement to Lee's large fan base and over 1 million followers on social media. I think that it's not an unfair extrapolation to describe that client as prominent.
The objection's overruled.
May I continue?
You may.
Lee Croddy is a very prominent client of yours, Ms. Sullivan. Is that correct?
You could say that, yes.
Therefore, it's reasonable to assume that the outcome of this court case could have a significant impact on your career, right?
I suppose it's a possibility, but I'm not too worried.
Ms. Sullivan, is that a yes or a no?
Yes.
Moving on, Ms. Sullivan, you observed the defendant's different interactions with many of their fans. Is that right?
Yes, I have.
Amongst all of these interactions, the defendant's conversation with Remy Montoya at the February 15th meet and greet stood out to you as unique, right?
Yes, but that makes sense considering how Remy was acting.
Ms. Sullivan, is that a yes or no to thinking the conversation was unique?
Yes, I believe I said yes.
From their various actions, such as the embrace they shared, you assume the defendant knew Remy quite well, correct?
I wasn't completely sure, but yes, at the time I did.
That's a yes to at the time you thought that Lee Croddy knew the person quite well.
Yes.
In fact, you even recalled her referring to Remy as a friend when she asked you to keep an eye on her, right?
I believe so, but Lee's always trying to form connections with her fans.
Ms. Sullivan, is that a yes or a no to Lee referring to Remy as a friend?
That was a yes.
Thank you, Your Honor. No further questions.
Redirect?
May I ask for a time check before I...
Yes.
Prosecution has 4 minutes and 50 seconds remaining for direct and redirect examinations.
This is
I'm sorry.
The defense.
I apologize. apologies once again, but there is a time discrepancy of 30 seconds.
Please proceed.
There is 5 minutes and 21 seconds, but once again, can we just split the time so we don't have to delay the trial further?
I'm sorry, you're saying how much? Let me.
I have about 5 minutes and 21 seconds remaining for the direct and redirect examination. And I was hoping we could just quickly split the time so we do not further delay trial.
We're not going to take as long again. Joshua, how much time do you have?
4 minutes and 50 seconds.
4 minutes, 50 seconds. And
I have 5:21.
let's split the difference. If we split the difference, what do we get?
It should be about 5 minutes and 10 seconds, I believe.
Okay. 5 minutes, 10 seconds left.
No redirect, Your Honor. May this witness be excused?
Yes. Please call your next witness.
The defense calls Lee Croddy.
Lee Croddy, are you present?
Yes.
Lee Croddy, please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Can you please state your full name and spell your last name for the record?
Lee Croddy, Croddy.
And for your honor's convenience, the statement for this witness can be found starting on page 36 of the case packet. Thank you.
Good morning, Ms. Croddy.
Good morning.
What do you do for a living?
Well, I'm the host of the YouTube show RCN, or The Right Choice of News, and we focus on revealing the truth on issues the mainstream media refuses to report on. I'm proud to say that RCN has over 1 million subscribers.
Do you ever interact with those millions of subscribers?
Well, of course. My fans are the reason why my channel is successful, so I interact with them whenever I can.
How do you interact with your fans?
Let's see, we have our group chats on Twitter, and we have live meet and greets and events, although those were before the pandemic and now we're online.
I want to talk about one of these group chats. Do you recall interacting with your fans on February 12th?
Yes, I do.
What was this group chat about?
Well, I recently received documents that confirmed a cover-up of aliens, so naturally I went to my group chat and I messaged with them and sent them a sneak peek of a video that I would be posting.
Who was part of this group chat?
Well, there was Remy Montoya and Zuri O'Neill, and I think 4 other people.
At any point during this February 12th group chat, did you intend for your fans to commit any crimes?
Well, of course not, no.
What did you intend to communicate with your fans through these group chats?
Well, I'm in a lot of group chats, and in all of them, our language gets passionate and we encourage each other to go out and take individual action, but to be honest, no one ever really did. So I thought this group chat was no different.
Let's shift gears and talk about one of the fans you mentioned, Remy Montoya. How do you know Remy Montoya?
Well, I've seen Remy at a couple of past meet and greets and events, and Remy is a fan, so of course I appreciate her.
And let's move on to February 14th. What, if anything, happened that day?
On February 14th, I messaged Remy, and I asked her if she could go to this government official's house and convince the official to let her in and share more documents and information about the cover-up. I would have gone myself, but I wasn't in the area.
Well, did you want Remy Montoya to break into the government official's home?
Well, of course not, no.
Well, did you want Remy Montoya to steal any documents?
Absolutely not.
Well, what did you want Remy Montoya to do?
Well, I expected Remy to be reasonable, to go to this house, knock on the door, demand the documents, not to break in and start stealing things.
And let's talk about what happened the next day, February 15th. What, if anything, happened that day?
On the 15th, I was at the Hale Cafe for our meet and greet, and then I saw Remy come up to me. She seemed shaken and started rambling, so I was worried for her mental health.
2 minutes.
What did Remy ramble about?
Well, I honestly have no idea. She was speaking so fast and so incoherently that I couldn't understand her at all.
What, if anything, happened next?
Well, I just wanted Remy to calm down, so I suggested she wait until after the meet and greet was over, and then come to my place. And so after the event, she stayed the night in my guest house.
And what happened after the meet and greet?
Well, after the meet and
Your
greet,
Honor, vague and ambiguous as to the time frame.
Overruled. Oh.
well, after the meet and greet, I drove her to my house, and then we went to sleep.
What happened when you woke up the next morning?
The next morning, I woke up and I saw Remy pacing around outside, but I didn't think much of it, so I just went back to sleep.
And when you finally woke up for that day, what, if anything, happened?
Well, I finally woke up.
1 minute.
Remy was yelling from the yard. I went to check on her, and that's when I saw her getting arrested.
Thank you, Ms. Croddy. Your Honor, no further questions at this time.
Ross?
Yes, Your Honor. Before we begin, the prosecution requests a time check.
Prosecution has 4 minutes and 30 seconds remaining for cross-examination.
Thank you. Good morning, Ms. Croddy.
Good morning.
Ms. Croddy, do you have a copy of Exhibit C on hand?
Yes, I do.
Are you familiar with Exhibit C?
Yes, I am. This is a text message conversation.
Is this a fair and accurate representation of your WhatsApp conversation with Remy Montoya as you remember it?
Yes, I believe so.
On page 50, lines 29 through 31, you sent a text to Remy Montoya that read, "I know you do, but we need those documents, Remy. You really need to get into that house tomorrow." Is that correct?
Yes, I did.
Ms. Croddy, on February 15th, the day of your meet and greet, several of your fans were present in Beacon Hills, correct?
I'm not quite sure. I think...
Croddy, by virtue of the fact that it is indeed a meet and greet, wouldn't several fans have been present for that meet and greet?
Oh, yes, during the meet and greet. I'm not sure about the before and after, though.
You specifically chose Remy Montoya to ask if she could get the documents, is that right?
Yes, I did.
You did this knowing that in the past, Ms. Montoya admitted to being violent towards someone she saw as an opposition to your movement, correct?
Yes, she shoved someone.
In fact, you admired Ms. Montoya for this show of dedication to your movement, right?
Well, I admire her passion, but we do still try to lead a peaceful movement.
But you did see the action as a violent one, is that right?
Objection, Your Honor. Objection, character evidence.
Your Honor, may be heard. Oh,
Overruled.
thank you. Ms. Croddy, do you have a copy of Exhibit B on hand?
Yes, I do.
Are you familiar with Exhibit B?
Yes, this is our Twitter group chat on February 12th.
Is this a fair and accurate representation of that Twitter group chat as you remember it?
Yes, I believe it is.
Your Honor, permission to move Exhibit B into evidence.
Any objection?
No objections, Your Honor.
B is moved into evidence.
Ms. Croddy, on page 49, lines 19 through 21, it's transcribed that you sent a message reading, "The person who wrote these reports was stupid enough to leave their name on it. I'll march right up to Marshak and demand the information." Is that correct?
Yes, I did say that.
To clarify, the person you were referring to in that message was Drew Marshak, correct?
Yes, it was.
In the sneak peek of the video you sent to this same group chat on February 12th, Drew Marshak's full name and address were visible, correct?
I believe it was in a photo of the documents that was embedded in the clip, so yes.
Mrs. Croddy, you sent a sneak peek of the video that you were planning to post to the group chat, is that right?
Objection, Your Honor. Asked and answered.
Your Honor, this hasn't been asked and answered. I never asked as to the content of the video.
The objections overruled.
Ms. Croddy?
I'm sorry, could you repeat the question?
Yes. In the sneak peek of the video you sent to this group chat on February 12th, the documents were in that video. Is that correct?
Yes, there is a photo of the documents in the video.
And in those documents, Drew Marshak's full name and address were visible, correct?
Yes.
Objection, Your Honor, asked and answered.
Your Honor, this hasn't been answered. The witness incorrectly identified having sent a photo to the group chat as opposed to a video.
Overruled.
Ms. Croddy?
Yes, and to clarify, the address was on a photo that was in the video clip.
Thank you, Ms. Croddy. Ms. Croddy, do you have a copy of Exhibit A on hand?
Yes, I do.
Are you familiar with Exhibit A?
It looks like a briefcase.
Is this a fair and accurate representation of that object as you remember it?
Your Honor, unfair extrapolation. May I be heard?
Yes.
Your Honor, this exhibit of the Agent Marshak's briefcase is not familiar to Lee Croddy because she never saw it as Agent Marshak's briefcase, and nowhere in her witness statement or the case packet does it state that Lee Croddy is familiar with this exhibit. Therefore, this question is asking for an unfair extrapolation.
Your Honor, may I be heard?
Yes.
Your Honor, on page 38, lines 37 through 38 of the updated case packet, Lee Croddy has testified in her witness statement, "I glanced at the briefcase, which definitely was official looking, and I thought I saw the outer part of a circular insignia." Opposing counsel seems to be insinuating that Lee Croddy doesn't know enough about the briefcase to recognize it in court, but does know enough about it to deem it as official looking, which I don't believe is an unfair extrapolation.
Your Honor, may I be heard?
Yes.
Your Honor, this briefcase is specific to Drew Marshak. My client does not know that this briefcase during that car ride is the exact one that esteemed opposing counsel is asking about in her cross-examination. Although she can deem it prop or official looking, she cannot testify to whether or not this is Agent Marshak's briefcase.
Your Honor, may I be heard?
Yes.
I'm not asking the defendant to testify to whether or not she recognized this as Drew Marshak's briefcase. I'm merely asking about the briefcase and its distinguishing features.
I know there's a briefcase at issue. There's been testimony in that regard. Your objections are going to go to the weight that I'll give it and not the admissibility of this item of evidence. Counsel's laying a good foundation. So I'm overruling an objection based on lack of foundation. Are you offering it into evidence, or are you simply doing more cross-examination at this time?
Your Honor, I believe the briefcase was already moved into evidence via Drew Marshak's testimony.
Oh, okay. Well, then you're just asking questions about her familiarity with it.
Precisely, Your Honor.
Okay, then the objection is overruled. You may continue your line of questioning.
Yes, Your Honor. Ms. Croddy, the briefcase has the name D. Marshak on it, does it not?
Yes, I can see in the photo.
It also has a logo for the California Department of Justice, right?
1 minute.
Yes, it does.
During your car ride with Remy after the meet and greet, you saw that same briefcase and thought it was official looking, did you not?
Objection, Your Honor. I bring up unfair extrapolation once more. I believe this has crossed the boundary of the question being simply about her familiarity with a briefcase versus it being this official briefcase in that car ride. Once again, Lee Croddy does not know during the car ride as she was driving and not paying attention to what Remy Montoya was holding, whether or not this was Drew Marshak's official briefcase.
Your Honor, may I be heard?
Yes.
Once again, my question is not asking for her to confirm that she thought it was Drew Marshak's briefcase in the car. It's asking about details of the briefcase and what her interpretation was at the time, which the witness may be allowed to answer as she pleases.
Your Honor, may I be heard?
Yes.
The question in specific that opposing counsel has phrased is, this is the same official briefcase in the car ride. That is asking Lee Croddy to testify that that briefcase in the car ride is the same one she knew to be Drew Marshak's, which is nowhere stated in the case packet.
Your Honor, may be heard.
The final time you're going back and forth and back and forth. Yes,
Yeah.
Kaolyn.
Okay. Ms. Croddy has already said that she is familiar with Exhibit A, and by virtue of that fact, I have deemed it the same briefcase because she has done so.
I'm going to overrule the objection. During argument, you can point out any flaws in the prosecution's reasoning defense. You may continue with the questions.
Ms. Croddy, I'll re-ask the question. During your car ride with Remy after the meet and greet, you saw that same briefcase and thought it was official looking, did you not?
Well, I'm not sure if it was this briefcase. You know, I only saw
Croddy,
it.
is that a yes or a no to thinking the briefcase in your car ride with Remy was official looking?
Well, it's
30
not
seconds.
a simple yes or no. I'm sorry. The briefcase I saw did look official, but
Thank you, Ms. Croddy. That's all I require. Ms. Croddy, once you returned to your home with Remy, you took her through a back entrance to your guest house. Is that right?
yes, that was just to make it seem sort of hidden.
Is that a yes or no to taking Ms. Montoya through a back entrance?
Yes, we went through a back entrance.
Thank you, Your Honor. No further questions.
Redirect.
Yes, Your Honor. Now, Ms. Croddy, on cross, you were asked about this briefcase. What, if anything, did you see in the car ride with Remy Montoya pertaining to this briefcase?
Well, the specific briefcase I have here, I'm not sure if it was that briefcase I saw in the car, especially since when Remy kicked it, it sounded kind of hollow, like a prop. So I assumed what she was holding was just like a prop briefcase. And all I saw of appearances was just the outer corner of an insignia. So I'm simply not sure what briefcase it was.
And Ms. Croddy, did you take Remy Montoya back to her home to hide her?
Well, of course not. Had I even known she had a reason to hide, I wouldn't have taken her back.
And during your text conversation that on cross you were asked about, did you intend for Remy Montoya to burglarize Agent Marshak's home?
Well, of course not, no. I never wanted Remy to do anything illegal, and not especially to break in, steal things, and then assault someone.
Thank you, Ms. Croddy. Your Honor, I have nothing further for this witness. May she return to counsel bench?
Yes.
At this time, the defense rests.
Okay. Okay, prosecution, would you like to give your closing arguments?
Yes, Your Honor. When Remy Montoya punched and robbed Drew Marshak on February 15th, 2020, she was not acting alone. While it is true that she had committed a crime, she did so at the behest of a manipulator, a puppet master, if you will. Your Honor, it was the defendant who fueled Remy's obsessions, singled her out for the crime, and convinced the young fan to carry out an act that she will regret for the rest of her life. The magic number here, Your Honor, is not one, as opposing counsel claims, it's two. 2 mistakes, 2 crimes committed, and 2 criminals in the courtroom here today. Now, expert witness Dr. Kai Chavez has revealed that since the very beginning, Lee Croddy used the group chats between her and her followers to perpetuate a toxic environment of groupthink, using inflammatory rhetoric and angry rants to create a hostile mentality among her fans. Your Honor, it was through this process of conformity and toxicity that the defendant ensured Remy's absolute loyalty to her cause. Now, CalCrim 400 and 401 explain that the defendant is aiding and abetting a crime when they know that the perpetrator had meant to commit a crime and still consciously help them do so. Your Honor, it is beyond any reasonable doubt that the defendant did just that. First, the defendant urgently pressured Remy to get the documents through private messages. We need those documents, Remy. You really need to get into that house tomorrow. Your Honor, these aren't the words of a kind or sympathetic person. These are the words of a puppet master pressuring a follower into committing a crime. Let us not forget that Lee Croddy is a professional journalist who knows just how powerful words can be. When the defendant was the one that indoctrinated Remy to her cause before ordering her to get the documents at all costs, it is clear that she knew exactly what Remy planned to do. Even Zuri O'Neill of the defense admits that Lee Croddy's words are meant to be taken literally and at face value. Your Honor, if she said she needed the documents, that meant she needed the documents. When she said she needed Remy to get into Drew's house, she meant exactly that. Second, Officer Bird reported how just days before, the defendant had given Remy two things: the name and address of Drew Marshak, clear proof of aiding and abetting. Not only did the puppet master pressure Remy into committing a crime, she also gave her all the tools needed to do so. Your Honor, it is no coincidence that out of all of her fans, the defendant singled out Remy Montoya, whom she knew for a fact had the address of Drew Marshak and whom she knew had a history of violent behavior to her cause to carry out the crime. Now, Kaolyn 440 furthers that the defendant can be charged with accessory if they knew that the perpetrator had committed a crime and still aided them in order for them to avoid arrest. Once again, Your Honor, it is beyond any reasonable doubt that the defendant did just that. Remy Montoya herself revealed how after robbing and assaulting Drew Marshak, she had told the defendant that she had gotten the documents and that she had a run-in with Ms. Marshak. Having just sent Remy to steal classified government documents, the defendant knew for a fact that Remy had broken the law. Even on the car ride back, Remy exclaimed that the government briefcase was not a prop. Two instances that ensured the defendant knew exactly what Remy had done. Instead of turning her into the police, however, or getting her professional help, as suggested by Erin Sullivan, the defendant instead took Remy in through the back entrance of her house. This, Your Honor, clearly meets the second condition of accessory. Housing a known criminal and taking her in through a back entrance is clear indication that the defendant was aiding the perpetrator in order for her to avoid arrest. At the end of the day, Your Honor, it is beyond any reasonable doubt that the defendant knew Remy meant to commit a crime, helped her do so, and aided her afterward. Like a puppet master pulling the strings, the defendant ensured Remy's unwavering loyalty through a toxic groupthink environment before pressuring her to commit a crime while giving her all the information needed to do so. After the act, with full knowledge of what had just transpired, the defendant took Remy to her house and hid them there using a back entrance, no less. Your Honor, the defendant has transformed Remy Montoya from a hopeful young fan into a criminal. The defendant has caused both physical and psychological pain to the victim, Drew Marshak. In the name of justice for the people, the state of California requests a verdict of guilty on both charges. Thank you.
Thank you, counsel. Defense, would you like to give your closing arguments?
Yes, Your Honor. Only one burglar, only one mind, only one criminal here. Your Honor, the prosecution has charged my client Lee Croddy for aiding and abetting burglary and acting as an accessory after the fact. However, the prosecution has failed to meet their high burden of proof of beyond a reasonable doubt because Remy Montoya is the only burglar, the only mind, and the only criminal here. Let's look at each charge one at a time. With respect to aiding and abetting burglary, Kaolyn 401 requires that my client knew that Remy Montoya would burglarize Agent Marshak's home, that Lee Croddy intended to aid and abet Miss Montoya in burglary, and that my client's words or conduct did in fact aid and abet Miss Montoya. At the outset, it is important to lay out exactly how Remy Montoya burglarized Agent Marshak's home. You heard today, Remy Montoya admit that she decided to look through the windows of Agent Marshak's home. She decided to enter that house through a window. She decided to bring a flash drive. She decided to download computer data. She decided to steal a briefcase, and she decided to assault Agent Marshak. Next, let's look at Lee's words and conduct. Out of all the exhibits and all the witness testimony the court heard today, the prosecution has failed to show any evidence of my client giving Remy Montoya these specific instructions. No mention of Windows, no mention of flash drive, no mention of computer data, no mention of stealing a briefcase, and certainly no mention of assaulting Agent Marshak. That is because my client wanted Remy Montoya to go down to Agent Marshak's home and demand for the documents, nothing more. This idea of being hailed a hero for stealing these documents came from Remy Montoya alone. It is Remy Montoya who went down to Agent Marshak's home and acted independently, as corroborated by Dr. Jes Beeart. As for the prosecution's argument around groupthink and creating a toxic environment, we can simply look towards Zuri O'Neill, who was part of that same 7-member group chat. Zuri O'Neill saw those conversations for what they were, mere venting among online friends. Remy Montoya is the only burglar here. Next, with respect to accessory after the fact, Calcum 44 requires that my client knew that Remy Montoya committed crimes.
2 minutes.
That my client intended to hide or help Remy Montoya escape punishment or arrest. Once again, the prosecution falls woefully short of meeting their high burden on both elements. Simply put, Lee Croddy did not know, because Remy Montoya never told her the severeness of her actions. Remy Montoya admitted that she had a run-in with Agent Marshak, a mere run-in, not that she assaulted Agent Marshak. She admitted that she got the documents, not that she stole the documents. Even more so, Remy Montoya admitted that she never shared the contents of the stolen briefcase with my client. Now, the prosecution would like to say that Lee Croddy brought back Remy Montoya to her home to hide her. But Your Honor, Ms. Sullivan testified today that Remy Montoya was acting panicked and Lee Croddy took her back to her home out of kindness. We ask that you consider that Lee Croddy did not immediately take her back to her home, that she had her wait at a public meet and greet, because Lee Croddy did not know. Remy Montoya is the only mind here. Your Honor, the prosecution has the burden of proof of beyond a reasonable doubt to prove that my client aided and abetted and acted as an accessory after the fact. However, the prosecution fails to meet their high burden, and more so, per the circumstantial evidence to show intent and knowledge, Calcum 224 states if there's one pointing to innocence and one pointing to guilt, the court must accept the reasonable interpretation pointing to innocence. Your Honor, my client did not know Remy Montoya would do these things and did not know that they did do these things. As such, find my client not guilty of both charges. Thank you.
Thank you.
May the prosecution proceed with the rebuttal.
Rebuttal.
Thank you. As for aiding and abetting, opposing counsel claims that Remy Montoya did everything on her own, but this is simply not true. Lee Croddy not only first ensured Remy's loyalty through a toxic groupthink environment, she also then singled Remy out specifically for her violent behavior and ordered her through private messages to get the documents at all costs. Even beyond that simple fact, she even gave her the address to get the documents. At the end of the day, Your Honor, without Lee Croddy's actions, none of this would have happened. It is clear that Lee Croddy not only knew Remy meant to commit a crime, she actively aided her in doing so. Opposing counsel claims, as per Zuri O'Neill, that the conversations were just harmless venting, but Zuri never saw Lee's direct private messages to Remy Montoya ordering her to get the documents. And as for accessory, let us not forget that after hearing Remy's confession twice, instead of turning her into the police or getting professional help, Lee hid her in her home using a back entrance. That alone is a testament to her guilt. Thank you, Your Honor.
Thank you. Defense rebuttal.
Yes, Your Honor. Now the prosecution has attempted to coddle their star witness, Remy Montoya, to an innocent young girl. But she is not innocent. She is a felon that is facing up to 5 years in prison. The only way out is to lie. To lie to the court and Officer Byrd that all she did was per the instruction of Lee Croddy. Remy Montoya and the prosecution are manipulating the story here. They're the ones acting like puppet masters, trying to twist my client's words into something they are not. Your Honor, my client's words were not of instructions. They were not of forcing Remy Montoya to go down to that house and get those documents. The prosecution has failed to meet their burden of proof. As such, the defense requests that you find my client not guilty on both charges. Thank you, Your Honor.
Thank you. All right, the 60-second rule is now being invoked. Would the parties like the 60 seconds to consult with their teacher or attorney regarding
Yes, Your Honor.
irregularities?
The prosecution would enjoy the 60 seconds.
All right. It's granted.
Thirty seconds. Stop.
Your Honor.
It's now, I'll ask the question first. Would the prosecution team like to note any trial irregularities?
Yes, Your Honor. It is the prosecution's belief that opposing counsel violated Rule 3.1c that stipulations may not be disputed at trial. During the redirect examination of Ms. Montoya, as well as during the closing statement rebuttal, opposing counsel disputed stipulation 7, which says, and I quote, Remy pleaded guilty to 2 felonies, first-degree robbery and assault on a peace officer, and agreed to give truthful testimony at Lee Croddy's trial. Truthful testimony shall be, for the purpose of this stipulation, testimony given based solely on the witness's memory of events and circumstances to the best of her ability without reference or influence of any third party. The violation was committed by claiming that it was impossible to confirm Remy's truthful testimony and during rebuttal that she has lied to the court and is somehow in corroboration with the prosecution.
Thank you. Does the defense wish to note any trial irregularities?
Yes, Your Honor. First of all, may I respond to the prosecution's trial irregularity of the dispute over the stipulations?
You get to do that?
Yes, Your Honor.
Okay, then. Let's hear your thoughts.
Your Honor, the stipulations themselves were not disputed. I believe that it is fair to question Remy Montoya's credibility. Truthful testimony, again, in the stipulation is based on memory and recollection of the events. And the credibility of Remy Montoya does not go to truthfulness, but rather, does not go to their recollection of events, but how they would act at today's trial.
All right, thank you. It is for the scorekeepers to factor in the objections as to any trial irregularities. That's not my role.
Your Honor,
yes.
May I be heard?
Yes.
I also noticed a trial irregularity. In the first time discrepancy, when I was conferring with the unofficial timekeeper, I asked her specifically how long her prosecution's third direct examination was. And I timed 3:25 from start to finish, while she timed 3:35. Now, this means that there is at least a 10-second difference between our times going into the fourth witness. However, when time was asked before the fourth witness, the unofficial timer said that there's a discrepancy of about 40 seconds. Your Honor, this means that an extra 30 seconds discrepancy was suddenly added. This is greater than 15 seconds, and this could mean one of two things. Either one, the unofficial timekeeper saw a discrepancy of greater than 15 seconds earlier in the trial, and both did not call it out and refused to let me know of this prior discrepancy. Or it can mean that given the unofficial timekeeper's job is to alert the court of time discrepancies, it's possible that the unofficial timekeeper could have intentionally added extra time to the discrepancy in order to cut our examinations short. And now, if this were the case, the defense has blatantly violated Rule 3.8c, modifications of time intervals, which are not permitted in trial. And a similar time discrepancy was also later called in court. And now, without deliberation between us, she called the court to split the time difference. Now, I'd like to point out that both these discrepancies resulted in more time for the defense and less for the prosecution. I just wanted to bring this up as a possible consideration to the court and the scores. Thank you.
Your Honor, may I also respond to that?
Yes.
Your Honor, the official clerk has a responsibility of keeping accurate timing, and the unofficial clerk, if there's a discrepancy of more than 15 seconds, must bring that to the court's attention. Now, I believe that the unofficial timed clerk is not doing this to gain an advantage, but rather to keep the trial honest. Your Honor, we split the time to keep it fair between both teams. Neither one got too much time added and neither one got too little time, and that did not affect the outcome of the trial. Also, the unofficial timer is not scored, so we do not know how to resolve this issue beyond it simply being that we split the time for fairness.
All right, thank you. As I indicated, it is not my role as the judge to determine those types of technical errors. I will note that I would not ascribe any bad faith actions to either side. I know
Your
that
Honor,
sides, yes.
Yes, Your Honor. I believe per the rule book, the judge is supposed to hear trial irregularities and address them if a rule violation is in fact has occurred. As such, as the judge, you have to rule whether a violation occurred so that the scores can take that into consideration. And that's per Rule 3.6K.
And how am I supposed to make that determination while I'm listening to the evidence and trying to take note of the performance of the parties?
Yes, Your Honor.
Your Honor, I would also like to make note to avoid any other confusion. The official clerk did say that I could have added time after this time discrepancy, but according to how the timing could occur and how timing mistakes happen, there's possibility that even though there's a large time discrepancy, that could be caused by either side. This time discrepancy could be a mistake on his side or my side. There's no way to determine that unless if we properly discuss it as we did in the trial. And as for the fact that he said that without discussing, I asked to split the time. I asked to split the time for the second discrepancy in court because in the previous time we had discussed the time discrepancy, we had taken a large amount of time and had delayed trial. And I wanted to avoid that. The official time clerk did have the opportunity to speak up verbally during trial if he had any concerns with that. And there was no mention, he did not mention anything, and that is not something I can control. I was simply trying to allow the trial to move on without causing further delay. So I just wanted to clear that up there.
I find, first of all, no bad faith actions by either side. You've all worked very hard. You're all very honest, and you're doing the best job possible. So begin with, I think that you're both acting in good faith. I am not convinced beyond a reasonable doubt that there's been a rule violation by either side. I'm comfortable with my decision splitting the time where there was any indifference. So I find no trial irregularities.
Thank you.
Thank you, Your Honor.
Your Honor, the defense has a few trial irregularities to attend to now.
And I find no irregularity regarding the time. Okay, so go on.
Yes, Your Honor. I believe in pretrial, the attorney addressed irregularities as to additional background research that may supplement their understanding of the issue at hand, but such background research may not be cited. First of all, there was 2 points in pretrial that no holding of custody was found in, or there was no mention of custody found in Stansbury v. California. And the prosecution mentioned that the burden of proof lies with the defense. However, this is not in the case packet, and the prosecution's understanding is incorrect. Excuse me, Your Honor. Now, prosecution holds the ultimate burden here of proving that there is no Fifth Amendment violation. However, in pretrial, they have changed that fact and made it so it is the defense's burden. As such, this was supplemental material that was added to the case.
Could opposing counsel repeat as to which case they were talking about? Was it Stansbury v. California as to where the violation occurred?
It's both Stansbury v. California as well as the burden of proof. Nowhere in the case packet does it mention the holding, and nowhere does it state the burden of proof.
All right, thank you. First of all, I do believe that pretrial irregularities are supposed to be addressed during pretrial time, not at the end of the trial. But I will look through the case packet right now, and I will see if there has been a violation.
Your Honor, may I be heard?
Yes.
Your Honor, as we have come to the revelation that the court must decide whether an irregularity has occurred, I believe in pretrial irregularities that was not either sustained or overruled, and as such, we're bringing it up now for the court's consideration.
Did you raise the issue at the time?
Yes, Your Honor. However, it was not ruled on.
If possible, could opposing counsel remind us which part of Stansbury v. California you said was not in the case packet?
The holding of custody in Stansbury v. California.
The holding of custody?
Yes.
That's what your issue was. It was not that the case had been removed from the packet or anything. It was simply he cited a fact that you believe was not included in the case materials.
Yes, there was additional information that was provided by the prosecution pretrial attorney that was not provided in the case, and that unfortunately gives an unfair advantage if there is a holding of custody or not.
Opposing counsel, with all due respect, does page 21 lines 1 through 3 not say the subjective and undisclosed conclusions of the officers involved generally should not bear any weight in the determination of custody?
Which lines are you reading from, counsel? Again?
Page 21 lines 1 through 3.
Counsel, your response?
Yes, Your Honor. Now we understand that the officer has no weight to custody. However, the pretrial prosecution attorney has stated that there was more custody in that case than the case at bar today. As such, they're claiming that Stansbury v. California has a holding on custody, which is nowhere to be found in the case packet.
Your Honor, I believe that Stansbury v. California is talking about how the subjective and undisclosed conclusions of the officers does have a holding or does have a bearing on whether or not there is custody in any specific case.
That is the holding. I will find no trial irregularity in regards to your objection for Stansbury.
And as for the objection to the burden of proof.
Could opposing counsel give us a second to just look through the case packet as to, or could you, could opposing counsel give us a second to look through the case packet?
Take a look.
Thank
Your Honor, may I be heard?
Yes.
Directing the court's attention to page 16, the fifth paragraph on that page.
Line number?
Page or lines 36 through 44. It outlines the conditions of pretrial, whether if a conditional statement is made, then the ruling should result in a specific ruling. And connecting that to the same page of 16, lines 6 through 13, it talks about this two-part test, which is what I referenced when I was referring to the burden for the opposing side. Taking these two sections from the case packet, if one of the sides was able to prove the if conditions in the fifth paragraph on that page, through that two-part test that is very clearly outlined in the second paragraph of that page, then the ruling would result in one way or another.
All right, so the defense has raised the issue as to a Miranda violation. And what was the argument by the prosecution? Was the prosecution, who was arguing, who had the burden? Remind me.
Your Honor, may I be heard?
Yes.
The prosecution was arguing that the defense had the burden of proof to prove whether or not my client was in a custodial interrogation. The case packet does not give the burden of proof to either the defense nor the prosecution. It is to the court to decide for this two-part investigation that prosecution is bringing up.
Your Honor, may I be heard?
Yes.
Looking back at my pretrial preparation, the only time the word burden was used was in this sentence. The defense's burden is that the conversation was designed deliberately by Bird to elicit the incriminating evidence from Lee. I believe that that's completely different from burden of proof, as it's synonymous to the defense's agenda or the defense's pretrial argument. The defense's pretrial argument requires that the conversation was designed deliberately and so on. And the reason I extracted that from the case packet was because of that fifth paragraph and second paragraph talking about the two-part consideration of custodial interrogation, as well as the conditional statements that must be met in order to get a ruling one way or another.
And Your Honor, may I be heard for the custody for Stansbury v. California?
I think I already ruled on that.
Yes,
Well, actually, no, we're still making our, I made my ruling on Stansbury. So I found no irregularities regarding that. So the issue now is the parties are objecting to who has the burden regarding the violation of the Miranda. If it is raised by the defense, the prosecution has the burden of showing under the California Rules of Evidence and the US Constitution that the prosecution has not violated his rights. So the burden does rest on the prosecution to show that there was no violation of the Miranda rights. As used by the defense, or rather as used by the prosecution, they weren't arguing the burden of proof as to the ultimate decision that the court has to make. So I'm not going to find a trial irregularity.
Yes, Your Honor.
Anything further?
Yes, Your Honor. And finally, the official clerk admitted to conversing with other team members. There are no exceptions to this rule per Rule 3.3a. Once the trial has begun, teachers, attorney coaches, substitute team members, and others are not allowed to communicate, signaling, messaging at any time during the trial. Once the trial has begun, other than what is permitted by the rules per unofficial clerk speaking and official clerk, as well as between attorneys, there must be no communication with student team members. If any section on Rule 3.3 is violated, scores must deduct 5 points per score sheet. Your Honor, once again, the clerk admitted to this during trial.
Care to respond?
Your Honor, it's true that the clerk did confer with the teammates, and it's also traditionally not allowed. However, when placed in a situation where the unofficial timekeeper is adamant that we subtract time, and we were unable to come to a consensus, the clerk decided that checking the time would be a reasonable action to further expedite the trial. And now, at this point where the time discrepancy exceeded 40 seconds, it is unlikely that the discrepancy was simply due to small mistakes. As such, checking time with others was a reasonable action to resolve the discrepancy and expedite the trial. In addition to this, Your Honor, the defense themselves admitted that they were communicating with their team. And I quote, "Well, I've been timing and so has others on my team. So why don't we just split time because we are delaying trial?"
Your Honor, may I be heard?
Yes.
Your Honor, the unofficial time clerk never said those words. I believe it is actually the official clerk that said I was checking with other team members and they have found no irregularities to time. As far as what our unofficial time clerk,
can she do that?
she cannot speak with other team members either, and she has not done so.
I thought you said she just
shot of the chat.
Your Honor may be heard.
Yes.
Your Honor, with all due respect, the statement that that the timekeeper just read was by the unofficial timekeeper. At that point, it is clear evidence that the unofficial timekeeper was also communicating with their team.
Your Honor, may I be heard?
Yes.
What I said was that, well, I've been timing, and so have been others, and so why don't we split the time? I never said that I checked time with my other team members. I know that all of my team members like to know how their own timing works. And I feel like this is very common amongst teams where you time yourself to be able to give yourself a signal as to what your timing is and how long your speech should be. Never in the text that the official clerk himself had said that I had checked with my other team members. I said that others on my team have been timing themselves. But I just know that. And if other people on my team had been timing themselves, I know I would have been notified if they had gotten the same time that he got. And that communication never happened.
All right, 2 questions. First, were you communicating with anyone else on your team?
No, I was not.
Did you receive any communications from anyone else on your team?
No, I was not. I did not.
Okay, all right, that settles it. There's been an admission by Joshua that he communicated with the other team, and there's no indication that the other side did so. So,
Your Honor, may I be heard?
no, we're done. I don't believe that you're a part of this portion. So there's going to be the irregularity found for the official timekeeper communicating with other individuals.
Yes, Your Honor.
Are we done?
Yes, Your Honor.
Okay. My scores, do you need more time or can I announce my verdict?
Your Honor, this is Jen French. I do not need any more time.
Your Honor, this is Natasha Robertson. I also do not need any more time.
Is there anyone else or is it just you two?
Your Honor, Chris Todd, no more time needed.
Okay. All right, thank you. That's my 3. I am going to announce my verdict, and then you all can turn on your cameras and we'll do the debrief. I find the defendant guilty as charged of both counts. That's based on the evidence that there was a clear direction to Montoya to obtain the documents. The defendant had knowledge of the defendant's prior history of violence and the clear indications to go to that residence and to obtain material could only be interpreted by a reasonable person to mean that the defendant was to, that Montoya was to try by whatever efforts possible to obtain that information. So Montoya was acting at the defendant's direction. After the incident had occurred, there's sufficient evidence beyond a reasonable doubt for me to find that the defendant also harbored him and therefore was an accessory after the fact. I find him guilty of both charges. Now, the debrief. People can turn on their cameras. Okay, I think this is my year 6 or 7 judging the competition, and I have never seen as spirited a debate, both an argument and preparation by the parties, as well as a very intensely fought struggle regarding any violations of the